I am calling to order this meeting of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. This is an additional meeting of the Committee of the Whole, not a regularly scheduled one. Today is Tuesday, November 1st, 2022. The time is 12:21 in the afternoon. This meeting is being conducted live in the council chambers, room 500 of the Johnny Wilson building, but also with some participation via the Zoom video conference broadcast platform. And this meeting can be watched by the public on Council Channel 13 live, and I believe also live on the council website, which is www.dccouncil.gov. As I said, this is an additional meeting of the Committee of the Whole. It will be followed by a legislative meeting, which is the regularly scheduled legislative meeting for the council for the month of November. We begin our Committee of the Whole meetings with calling the roll to determine whether we have a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Allen.
Here.
Councilmember Bonds.
Here.
Councilmember Che.
Here.
Councilmember Gray. Councilmember Gray. Councilmember Henderson.
Here.
Councilmember Lewis George. Councilmember Lewis George. Councilmember McDuffie. Councilmember McDuffie. Councilmember Nadeau.
Here.
Councilmember Pinto.
Present.
Councilmember Silverman.
Present.
Councilmember Robert White.
Present.
Councilmember Trayon White.
Present.
Mr. Chairman, you have a quorum.
Thank you, Mr. Cash. We have 5 items for markup in the Committee of the Whole. The first is the Omnibus Bill 24-455, the Omnibus Uniform Athlete Agent and College Athlete Name, Image, or Likeness Amendment Act of 2022. That name that I just said is slightly different than what's on the agenda because it includes the word uniform. This legislation would regulate student athlete compensation for their name, image, and likeness. And it would update the Uniform Athlete Agents Act, which the council adopted over 20 years ago. The committee print merges both of those uniform bills, which were introduced as Bill 24-455 and Bill 24-456 into Titles 1 and 2 respectively. And the committee print also incorporates into Title II provisions of Bill 24-445 concerning financial literacy. Title I of the bill would enact the revised Uniform Athlete Agents Act with minor changes. The Uniform Athlete Agents Act was adopted by the council in 2001 and has been enacted in 40 states, 40 states. This title will not only protect educational institutions in the District of Columbia, but also the student athletes that attend them as well. Further, this title will provide uniform regulation to address issues arising from activities of agents who attempt to recruit student athletes in a manner that had previously caused them to lose eligibility and damage promising professional careers. Title II of the bill establishes a legal framework for permitting college athletes to receive compensation for their name, image, and likeness, otherwise known as NIL, their name, image, and likeness rights, and provides parameters on the types of activity that athletes may engage in. This title prohibits illegal activity in specific categories of name, image, or likeness activity that are prohibited, and specific categories that are prohibited, which includes alcohol, tobacco, steroids, gambling, etc. This title also allows institutions to adopt a policy to prevent name, image, or likeness activity that the institution determines would have an adverse impact on its reputation, provided that the institution complies with the same policy with respect to the institution's sponsorships. This title also contains several permissible actions. However, a lack of a comprehensive list of all permissible institution activity should not be construed that the institution is limited to only listed actions. Title II also includes a provision taken from Bill 24-445 that requires educational institutions and athletic associations and conferences to educate college athletes about name, image, and likeness compensation and contracts by offering financial literacy and life skills programming. The committee believes financial literacy is an important part of education and critical to student athletes who may earn significant income from their name, image, and likeness. Bill 24-445, from which the financial literacy provisions are taken, was introduced on October 14, 2021 by Councilmember Henderson and joined by 5 other council members. Bill 24-455, the Uniform Athletes Agent Act Amendment Act, was introduced on October 19th at the request of the Uniform Law Commission, and Bill 24-456 was also introduced on October 19th at the request of the Uniform Law Commission. The Committee of the Whole held a hearing on the 3 bills on September 28, 2022. I think it's fair to say that there was no comment or testimony in opposition to the bill, but there was quite a bit of discussion about the 3 bills and preferred definitions and so forth. I move the print with leave for staff to make technical and conforming changes. Is there discussion? Councilmember Allen.
Thank you very much, Mr. Chairman. I'm going to just kind of raise the same thing we talked about in our breakfast meeting, just to make sure it's on the record, and look forward to working with you and your team. I agree that college athletes should be able to enter into NIL deals. I think we all understand, and it's probably why you didn't have a whole lot of testimony against something like this, is that it is a long-standing injustice, allowing universities to create and rack up massive profits based on the performance of student athletes, in particular high-profile Black athletes. Just to help drive that point home again, when we think about NCAA football, one of the most prominent spaces where they make so much money, they paid last year more than $100 million to coaches and buyouts just for them not to coach. They're on pace for another $100 million that they'll pay out to coaches to not coach, as they have fired coaches. It has a just massive inequity in it. The one piece that I would like to just work with you to make sure we fully understand, and again, recognizing that this is uniform law, so you're trying to create consistency across the states. But one concern I have is just around where a university is allowed to prohibit an NIL agreement, because the language says the institution should the institution determine it has an adverse impact on its reputation. And I think that can be defined in many different ways. In particular, for example, if there was a religious university that wanted to prohibit an athlete from an endorsement from Planned Parenthood, as an example, something where a student athlete may feel very strongly about one position and want to enter into an NIL, but the university doesn't, but it's unclear about if that would actually impact reputation per se. So I just wanted to flag that, Mr. Chairman, around that one issue, and look forward to working with you and your staff just to make sure that we have some clarity around it. And if we need to or should tweak that a little bit, happy to work with you between now and second reading. Thank you.
Thank you, Mr. Allen. You did raise it earlier, and I'm glad you're bringing it up here because I think the colloquy is helpful. I believe section 6D is intended to prevent an institution from prohibiting. So there are different ways of reading this, what a student could do or what the institution may not do. From the latter, the section is intended to prevent an institution from prohibiting a college athlete from engaging in name, image, or likeness activity. Prevent an institution from prohibiting that with a third party or a category of third parties if the institution engages in any sponsorship or endorsement activity with that third party or category of third parties. The language itself is an institution may adopt a policy to prevent a college athlete from engaging in name, image, or likeness activity that is illegal. Or if the institution complies with the same policy with respect to the institution's sponsorships and similar commercial activity, the institution determines has an adverse impact on its reputation. An institution that adopts a policy under this subsection shall disclose the policy and the institution's rationale in a record maintained on the institution's website that is accessible by the public and electronically searchable. So it can't just be that the institution says, yeah, this is going to damage my reputation, don't want you to do it. They actually have to have it in writing. It's part of their policy. And it can't be a double standard where you as an athlete can't involve in an NIL activity and get compensated for something that the university says, no, you can't, while at the same time, the university is doing. The bill that we have follows the uniform language, but it does specify some specific prohibitions, such as alcohol, tobacco, firearms, adult entertainment, there are a few others. So I hope that clarifies. And if you have additional concerns, I'm happy to work with you between now and second reading.
Yeah, absolutely. I appreciate that clarity there. I do still have a couple concerns, so we can certainly work between first and second reading. I think, again, this is putting restrictions into code. And so I obviously from the criminal code perspective, which we'll be talking about later, I know when we have terms that are sometimes feel a bit vague or open to interpretation, it could have an unintended consequence down the road. So just want to make sure we look at that. But again, I
Yes.
appreciate that and the willingness. Thank you very much, Mr. Chairman.
Yes, and I want to add that this is a uniform law, and we tried to closely adhere to the Uniform Law Commission's language, which in some instances isn't the same as our own drafting format. But as a result, there's a body of interpretive, I don't want to put this, body of interpretation that explains what the Uniform Law Commission intended.
Like case law. Yep.
Well, it wouldn't be case law, it's uniform law. You need to move that.
Blocking your view.
Yes, you're blocking.
Thank you.
So, just like we have a bill coming up in which there's a lot of interpretive
Correct.
explanatory material that is helpful.
Mr. Chairman,
Yes, Mr. McDuffie.
I wanted to ask, thank you and your team for working on this, given the significance of this nationally, what we've seen in terms of the law lately, but in terms of the hearing and the testimony and the participation by the public or people who might be impacted by this, were there any athletes, any sports agents, any attorneys representing, managing, any industry experts associated with the hearing? Do we have any testimony on record about what the impact of this law is going to be? I appreciate that it's a uniform law, but I'm just curious.
Well, we had, it was a hearing, so it had the full 15 days, and I think the notice was actually published in the summer, like August. So there was the opportunity. No, there weren't, there were no athletes who testified. There were a couple of individuals who were associated with the Uniform Law Commission, but actually are very much involved in this business. I recall one of the witnesses, I believe was from a university. I want to say in one of the southern states.
Tulane
Tulane?
University.
Yeah. So he, I would say, is practicing in this area, but he was testifying with the Uniform Law Commission.
Okay, I would just encourage maybe some outreach, and I'm happy to work with you and your team to see if there's any input we can get from folks locally who might be impacted by this or who've worked on this.
Actually, I'm sorry to interrupt. We did have a representative at the hearing from the consortium. That's the consortium of universities. And following the hearing, we had quite a bit of input from at least one of the universities, Georgetown University.
That's great. What about students who play at Georgetown or any of the other universities?
We did not, I'm not aware of input from them.
What about individual athletes or others who might be on the other side of this? I don't want to create it as if it's some sort of adversarial thing. I don't think it necessarily is, but just trying to make sure different perspectives and experiences are reflected, given a lot of folks who've been impacted by this for years have been the athletes and the folks who benefited from this before the law was changed were the colleges and universities and the leagues associated with them. So I just want to make sure that we're doing some outreach to try to make sure that the people who had not been represented or who are now being afforded the opportunity to benefit from their name and image and likeness, if they would like to, have the ability to weigh in. So that's all.
Sure, it's a fair point. The legislation actually is intended to protect the students.
Oh, I follow it. I just want to make sure that they follow it and they might, have something that they'd like to share that we're not aware of at this point.
Sure. Councilmember Henderson.
Mr. Chairman, since this is a bill from the committee of the whole, I can make a statement, correct?
This is open for debate.
Okay, great. Wonderful. I wanted to thank you for moving quickly to mark up this bill after the hearing and for including provisions from my bill, the College Student Athlete Compensation Amendment Act of 2021 in this omnibus. I introduced that legislation to respond to the changing landscape for college student athletes following rulemaking by the NCAA permitting athletes to be paid. That allows for student athletes to be paid for publicity and endorsement deals known as name, image, likeness. While you did not move my bill as the primary vehicle for these necessary provisions to provide guidance to and protect college athletes, I am glad that you included the provisions requiring universities to provide financial literacy education to student athletes and the list of categories that DC student athletes are prohibited from endorsing in exchange for compensation. And thank you.
Thank you, Councilmember. Any further discussion or questions? The vote is going to be on the print with leave for staff to make technical and conforming changes. Mr. Cash, would you call the roll?
Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman. Councilmember Silverman. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Mr. Chairman, there are 11 yeses and 2 absent.
The print is approved unanimously. I move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion? We'll do this by a voice vote. All those in favor of the report with leave for staff say aye.
Aye.
Opposed? The ayes have it unanimously. Madam General Counsel or Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next item for markup is Bill 24-528, W. Cardell Shelton Way Designation Act of 2022. The purpose of this legislation is to symbolically designate Upsall Street between First Street and Second Street in the southeast as W. Cardell Shelton Way. The location is in Ward 8. William Cardell Shelton was born in the District of Columbia and was a resident of Ward 8 for more than 75 years. He was a graduate of Phelps Vocational High School and would later be a champion for vocational education for district youth. Mr. Shelton was an advisory neighborhood commissioner and also ran for the Ward 8 school board seat as well as a council seat. Mr. Shelton passed away in 2017. Some members will remember him. He was very vocal about vocational education for district youth and also for many issues that were important in Ward 8. This legislation was introduced by Councilmember Trayon White with 6 other council members on December 1st, 2021. The Committee of the Whole held a public hearing on July 6, 2022. The committee has received no testimony or comments in opposition to the bill. Without objection, I'm going to move both the print and report with leave for staff to make technical, conforming, and editorial changes. Is there discussion?
Yes, Chairman.
Councilmember White.
Yes, Chairman, Mr. Shelton, who was born in Washington DC and the second child of 6 parents. I was a proud native Washingtonian, not just in Ward 8, but across the city for more than 75 years. Mr. Shelton was a master brick mason who worked on projects such as the Empire State Building, Harambe House, Ed Murphy Super Club, Radios One WOL. He served as a mentor to craftsmen and small contractors in the DMV area. Mr. Shelton became president of the Southeast General Construction Company and later president of the Anacostia Professional Merchant Association. He is a liaison for the Korean merchants in the district. He was a liaison for the Korean merchants in the district, a champion for opportunities, access, and equal treatment. And as you noted, Chairman, a strong fighter for men and women in the city to get skills doing handyman work and even construction. He pushed that with the youth as often as I saw him. Mr. Shelton served as the Ward 8 ANC and was often the guest commentator on WOL. He was a role model, advocate, and loyal friend to Ward 8. And it's an honor to get this to the council to support naming this street after him as a ceremonial street naming. Thank you, Chairman.
Thank you, Councilmember. Any further discussion on the bill? The vote is on both the print and report. Mr. Cash, could you call the roll?
Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The print and report are approved unanimously. Madam General Counsel, Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report is filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. There's no objection. We'll consider the next 2 items together. They're both confirmations of mayoral nominations to the District of Columbia Commemorative Works Committee. PR 24-818, District of Columbia Commemorative Works Committee, Otto Condon Confirmation Resolution of 2022. And PR 24-893, District of Columbia Commemorative Works Committee, Joe Coleman Confirmation Resolution of 2022. The Commemorative Works Committee was established by the Commemorative Works on Public Space Act of 2000. The Commemorative Works Committee advises and recommends to the mayor and the council a disposition of each application to place a commemorative work on public space in the district. The committee is to develop criteria to review, evaluate, and approve commemorative works in the district, review all applications for commemorative works, refer applications to affected advisory neighborhood commissions and to the National Capital Memorial Commission for comment, and then recommend to the mayor and council disposition of each application. The Commemorative Works Committee is to be composed of 12 voting members, 3 citizen members, each appointed by the mayor with the advice and consent of the council for a 3-year term, and 9 government officials or their designated representatives. The Director of the Office of Planning, Director of the Department of Parks and Recreation, the Director of the Department of Public Works, the Chief Property Management Officer, the Executive Director of the Commission on the Arts and Humanities, the Chair of the Historic Preservation Review Board, the Secretary of the District of Columbia, the Director of the Department of Consumer and Regulatory Affairs, which should say Department of Buildings, and the Director of the Department of Housing and Community Development. The citizen members of the Commemorative Works Committee must display an active interest or ability in the visual arts, architecture, civic design, or history. PR 24-818 would confirm the mayor's nomination of Mr. Otto Condon for reappointment to the Commemorative Works Committee for a 3-year term expiring July 22nd, 2025. Mr. Condon is currently a resident of Ward 1. He is an urban design principal at ZGF Architects LLP. He has considerable experience working with local and federal agencies, developers, business improvement districts, and community organizations. He has completed urban design projects in all 8 wards and has focused on the district's underserved communities. The purpose of PR 24-893 is to confirm the mayor's nomination of Mr. Joe Coleman for reappointment to the Commemorative Works Committee for a 3-year term expiring July 22nd, 2025. Mr. Coleman is currently a resident of Ward 7. He is a native Washingtonian and a freelance artist in the district, concentrating on sculpture, murals, and portraiture, and dermal canvases. I'll repeat, dermal canvases, also known as tattoos. He has been a passionate arts advocate, educator, and professional practitioner for nearly 20 years. Mr. Coleman is an accomplished artist, having been commissioned by presidents of 2 African countries, several universities, and the National Museum of African Art for his portraiture and mural work. His work can be found throughout the district. Some of his projects include the Marion Berry mural in Ward 8, the entrance to the DuPont Underground, a memorial portrait of Thurlow Tibbs, a bronze fist bump sculpture for the Berry Farms Recreation Center. He's currently working on sculpting 15 bronze medallions for the Howard Theater Walk of Fame. In 2009, he founded the Slickfish Education and Therapy, which provides social skills therapy for children with autism spectrum disorders. PR 24-818 concerning Otto Condon was introduced at the request of the mayor on June 17th, 2022. PR 24-893 concerning Joe Coleman was introduced at the request of the mayor on July 12th, 2022. The committee of the whole held a public roundtable on both nominations on October 12th, 2022. The committee has received no testimony or comments in opposition to either of the nominees. Without objection, I move the prints and reports for both PR 24-818 and 24-893 with leave for staff to make technical conforming and editorial changes. Is there discussion on the motion? Mr. Cash, would you call the roll? The vote is on both PR 24-818 and 24-893. The prints and reports with leave for staff.
Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The prints and reports for both are approved unanimously. Madam Assistant General Counsel, are these measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Once the reports and hearing records are filed.
Madam Budget Director, do the measures fiscal impact statements comply with council requirements?
Yes, they do.
Without objection, these measures will be placed on the consent agenda for today's legislative meeting. The last item for markup in the committee of the whole is PR 24-932. Executive Director of OANC Kent Base Appointment Resolution of 2022. The purpose of this resolution is to appoint Mr. Kent Base as the Executive Director of the Office of Advisory Neighborhood Commissions, replacing interim Executive Director Shanette Grant on an at-will basis. Since October 5th, 2021, Ms. Shanette Grant has served as the interim Executive Director of the Office of Advisory Neighborhood Commissions, or OANC. She replaced Gottlieb Simon, who previously served in the role. In the fiscal year 2023 budget, the council provided a substantial funding increase for OANC for more OANC staff and a strategic plan. In addition, the budget significantly increased ANC allotments beginning on October 1st, 2022. Selection of a new visionary permanent director at this time will equip the Office of Advisory Neighborhood Commissions to empower ANCs with these new services and supports. The executive director of the OANC is appointed by resolution of the full council based on the recommendation of the chairman. In late 2012, Councilmember Robert White. I don't know why that says 2012. In late 2020. I'm even going to say 21, in late 2021. Robert, were you on the council in 2012? But we'll fix that. But at any rate, Councilmember Robert White, Chair of the Committee on Government Operations and Facilities, which has oversight of the Office of the Advisory Neighborhood Commissions, held a hearing where the committee heard from commissioners about what they wanted to see in the next OANC executive director. Earlier this year, that committee held another hearing focused on a new vision for OANC. After the council solicited prospective candidates to lead the OANC, Councilmember Robert White interviewed a number of candidates and made recommendations to me. And I, in turn, selected Mr. Kent Bass for appointment by the council as executive, to be the executive director of the OANC in the accepted service. Mr. Bass is currently a resident of Ward 1 and has served as an ANC commissioner for 12 years. He has a bachelor's degree from the University of Illinois, a master's of science and design from Arizona State University, and a master's of information and library science from the Catholic University of America. Mr. Bass has 15 years of professional management experience and 27 years of library experience. This experience will be vital to the OANC as the office seeks to modernize its services, including document management. Mr. Bass has a strong background in managing a team and has a long record of service as a commissioner. Assuming that we approve this, the committee believes that Mr. Bass has the potential to reinvigorate the OANC and provide collaborative support to the ANCs. This resolution was introduced on September 19th of this year. A public hearing was held on October 12th of this year. And I move the print and report with leave for staff to make technical conforming and editorial changes. I want to note that we intentionally, and I say we, including Councilmember White, wanted to ensure that there was at least 30 days between introduction of the resolution and today to afford ANCs the opportunity to comment. And we, at the public hearing, there was some opposition, which seemed to center on the Park Morton development. And otherwise, there was, I would characterize, widespread support across the city for this appointment. Councilmember White, do you want to say anything?
I would love to, Chairman.
Please.
Thank you, Mr. Chairman. I so appreciate you moving forward this appointment of Kent Bass as the new permanent executive director of the Office of Advisory Neighborhood Commissions, or OANC. As you know, my committee has been supporting a once-in-a-generation transformation of the OANC for several years now. That transformation has included dramatic new funding for ANCs, including funding for new hybrid meeting technology, language translation, sign language interpretation, community engagement technology, development negotiation assistance, joint printing and technology services, and implicit bias and conflict resolution training. We have also funded 5 new staff in the new strategic plan for the OANC over the last several years, and significantly increased allocations that flow directly to the ANCs themselves. Recently, Mr. Chairman, your team also worked with my office to ensure that newly established ANCs will have the financial resources they need to get up and running next year. Now we need a new permanent executive director of the office to ensure those earlier investments are having the effect we intended and to chart a path for the future of the OANC and our ANCs. While the OANC has benefited from the leadership of Gottlieb Simon and Shanette Grant over the past years, Kent Bass will provide an exciting opportunity to re-envision and reinvigorate the OANC. As you know, Mr. Chairman, my committee held a hearing late last year where we heard from commissioners about what they wanted to see in the next director of the OANC. This spring, we had a second hearing on what commissioners wanted to see in the future of the office. My committee accepted numerous exceptional applications for the role of director, and I had the privilege of interviewing a number of those candidates and making recommendations. I focused on finding a visionary thinker who will prioritize supporting our ANCs, engaging existing staff at OANC, and supporting the continued growth of the office. Despite the strong competition, Kent Bay stood out among those applicants, given his experience and leadership at ANC 1A, as well as his management experience in the private sector at Wiley Rain and Greenberg Trug. We also heard strong support from ANCs for this appointment through the hearing. Therefore, I am proud to support this appointment today, and I look forward to many years of him answering the question of how you pronounce his last name. Thank you, Mr. Chairman.
But I think we know how to pronounce it. Base.
It's not phonetic.
Further discussion? The motion is the print and report with leave for staff. Mr. Cash, would you call the roll?
Councilmember Silverman,
Yes.
Councilmember Silverman votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White,
Yes.
Councilmember Trahan White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Che,
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Louis George,
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 12 yeses, 1 absent.
The print and report are approved unanimously. Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. That completes items for markup in the committee of the whole. From here on, we're limited to questions. We have a number of measures reported out of the Committee on Housing and Executive Administration chaired by Councilmember Anita Bonds. The first is Bill 24-430, the Limited Equity Cooperative Advisory Council Act of 2022. Councilmember Bonds. Would you turn your microphone on?
All right, I'm very sorry. I thought it was on. Today, I'm moving Bill 24-430, the Limited Equity Cooperative Advisory Council Act of 2022. And I want to thank my colleagues and co-introducers, including Council Members Shea, Henderson, Nadeau, Pinto, and Robert White for helping me with this bill. This legislation would establish a permanent advisory council model from the Limited Equity Cooperative Task Force that was created in spring of 2018. The purpose of the task force was to provide recommendations to the council and the government on how to best stabilize, strengthen, and preserve existing limited equity co-ops while supporting the formation of new LECs. To provide some basic understanding, the LECs have the same structure as traditional co-op buildings, which achieve the collective ownership of residents. LECs, however, offer low to moderate income home buyers a below market buy-in and restrict the profit that residents can make from the resale, ensuring that units remain affordable into perpetuity. The district has a longstanding history with LECs as they have garnered support from the district for over 40 years. And currently, the district has over 4,000 LECs units across almost 100 buildings. Because LECs offer below market buy-in, they are an excellent affordable option for those seeking that first home purchase. The bill is important to me because I'm a strong believer in the power of home ownership, and the advisory council would provide advice to the government by experts in the LEC world. Further, the bill will ensure that policymakers in the district remain well-equipped to pass legislation that supports and expands this important model of affordable homeownership. I urge my colleagues to support this bill today to take another step towards materializing homeownership for low-income and first-time home buyers in the district. And thank you, Mr. Chairman. And now I move this bill.
Thank you, Councilmember Bonds. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 24-431, Limited Equity Cooperative Property Tax Assistance Amendment Act of 2022. Councilmember Bonds.
Yes, Mr. Chairman, let's see. Thank you again. I'm moving on Bill 24-431, Limited Equity Cooperative Property Tax Assistance Amendment Act of 2022. And I want to thank my colleagues again. It was introduced by myself along with Council Members Shea, Henderson, Nadeau, Pinto, and Robert White. This legislation will amend Title 47 of the DC Official Code to expand the current 5-year LEC tax abatement to a permanent property tax abatement for those LEC members whose household incomes is less than 80% of the area median income. In LECs, where at least 50% of the cooperative households are also less than 80% AMI. Likewise, this bill additionally amends the DC code to elaborate on the definition of LECs by requiring them to include membership limitations within its articles of incorporation or organization for the purpose of placing limitations on the household incomes of a potential buyer. Before the original LEC task force expired in 2019, they explicitly advised the council to enact a full permanent property tax abatement for LECs to offer much needed ongoing support for their existence within the district. A permanent LEC tax abatement curtails the financial burdens LEC members face at the end of the current 5-year abatement period by creating uninterrupted affordability for its members, because a permanent tax abatement is critical to alleviating the current affordable housing dilemma in the district by increasing financial stability for existing LECs. Currently, after the 5-year property tax exemption expires, LEC owners incur additional costs that can average anywhere between $350 to $1,000 per unit, creating dramatic financial hardships for many members. Moreover, the permanent tax abatement would make the creation of new LECs more obtainable, where we often see homeownership as too cost prohibited in the district. This effort would bolster the viability of the LEC model and encourage the participation of Washingtonians by increasing their apprehension of affordability after the 5-year period. This is different from workforce housing, which focuses on the developer's benefit. This tax abatement will reduce the tax burden for owners who may occupy the unit or a share of the enterprise. With a permanent tax abatement, current and potential LEC, 30 seconds.
Without objection.
Thank you. And potential LEC members may focus their financial resources on covering operating expenses and mortgage payments rather than agonizing about the possibility of displacement due to costly property taxes. I strongly urge my colleagues to support the bill today to continue our efforts in preserving affordable housing in the district. And thank you, Mr. Chairman, and I move the bill.
Thank you, Councilmember Bonds. Are there questions from members? Councilmember Lewis George.
Thank you. I just had one question because I was looking at the core report. The core report flags some serious concerns about allowing homeowners to not limit the resale value of their units. If we start seeing a trend where LEC owners are only using the income level of a buyer, and LECs begin really being priced out of affordability reach of that 40 to 60% MFI earners. What are options for pulling back that sales strategy flexibility that we're creating here? And are there unintended consequences of opening this door now and then not being able to close it later?
Councilmember Bonds?
Thank you very much. Thank you for the question, Councilmember Lewis George. There are, well, we are creating this or attempting to create this through law, and I think we would use the same mechanism to manage a situation if it gets out of hand. And so that's how I'm looking at this. The idea is to use as many tools as we have available currently to sort of speed up this model, because this model is so beneficial to those who, let's say, have about $10,000 to begin ownership, as opposed to 30,000 or maybe 50,000 as today's market is. And so we're doing everything we can to come up with tools that will help people become homeowners. And I hope that kind of answers your
Yeah,
question.
it does. Thank you. Thank you so
Mhm.
much.
Thank you, Councilmember. Any further questions? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next measure is Bill 24-653, Period Equity, Writing, and Injustice of District Residents Act of 2022. Councilmember Bonds.
Thank you again, Chairman. I'm delighted to move forward with this important legislation today. Bill 24-653, Period Equity, Writing, and Injustice of District Residents Period Act of 2022 is a critical step in the fight for menstrual dignity and human rights. Lack of access to period products is an issue that can create serious health consequences, which are exacerbated by those living in poverty and those with intersectional identities. Women, transgender men, and non-binary people, menstruating people, that is, who lack access to menstrual products are more likely to reuse products or use products for too long, increasing their risk for infection and other conditions that require medical care. By requiring period products in public buildings and facilities, we can help our most vulnerable populations face one less barrier to ensure their basic needs are met. At the public hearing, we received overwhelming support for the bill. We also heard many stories highlighting the distressing and often traumatic shared experiences of administrators. Passing the Period Act sends a powerful message that no matter your circumstances or identity, DC will fight to ensure that you can live your life with the safety, privacy, and dignity that every individual deserves. I look forward to passing this bill and bringing us one step closer to addressing the period inequity in our city. And I thank you, Mr. Chairman, and I now move this bill. And I think Councilmember Pinto may have a comment. He's the author of the bill.
Let's see in a moment, although it's supposed to be questions. Councilmember Pinto?
Thank you, Mr. Chairman. I am so proud that we're voting today on the Period Equity, Writing, and Injustice of District Residents Act of 2022, Period Act. This is a bill that I introduced at the beginning of this year, and it's the second period equity bill I've introduced since joining office. This bill builds on the progress that we made earlier with the Expanding Student Access to Period Products Act by not only requiring free period products in all school bathrooms, but now in all DC government buildings, like this one, like the DC jail, homeless shelters, libraries, community centers, and more. Thank you so much to all of our colleagues who co-introduced the Period Act and your recognition that access to these products is a necessity for over half of our population. By requiring these products in all public restrooms, we are working together to combat period stigma and poverty and beginning to treat period products like toilet paper rather than a luxury item. Many people don't realize that period products are not covered by SNAP or WIC. And as a result, each month, menstruating people, many of whom are forced to choose between purchasing period products and other basic necessities. This first came to my attention when I was in law school and was standing in line at the grocery store when a woman asked me if I would purchase her period products in exchange for her buying my food with SNAP. I knew then that we needed to do something about this injustice. Menstruating people deserve to be treated with dignity and respect. And I want to thank also the dozens of public witnesses who testified at the hearing. Their involvement and activism made this bill stronger. Since hearing from them, we've included language to ensure that period products that we're providing are toxin-free and plastic-free. This bill demonstrates that when community voices are involved in public policymaking, they push us to think about the intersectionality of so many issues and craft stronger legislation. So looking forward to passing this bill today and including funding in next year's budget. So, Madam Chairwoman Bonds, I would like to ask you, are you just as excited as I am to pass this bill today?
Yes.
I'm sorry, was that a question?
Yes, we all are.
Asked and answered, Mr. Chairman. Thank you.
Is there further questions with regard to the bill? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next item is Bill 24-934, Condominium Warranty Claims Clarification Amendment Act of 2022. Councilmember Bonds.
Yes, Chairman, trying to find my remarks. Bill 24-934 amends the Condominium Act of 1976 to clarify the standards and procedures governing the resolution of a claim filed upon a condominium developer's warranty against structural defects and to clarify the power and responsibilities of the mayor in such cases, among other technical changes to the law. It does expands the definition of structural defect to include certain violations of district building codes that result in demonstrable harm to health or safety, establishes a clear process for ensuring the warranty security payment is posted in the correct amount prior to the sale of condominium units, requires the mayor to maintain a publicly available online record of the warranty security amounts and the form of warranty security for each project, establishes clear notice requirements and timelines for parties to file and appeal claims on the warranty security, establishes a clear process and deadline for the Department of Housing and Community Development to release the warranty security funds, establish a right to de novo review by the Office of Administrative Hearings, clarifies that in a suit for breach of warranties, the prevailing party is entitled to attorney fees, establishes fines, imprisonment for knowing or recklessly violation of this section, and authorizes the mayor to suspend stakeholders directly involved in fraud related to condominium developments from participating in the sale of condominium units in the district, and it requires the mayor to establish a fund to provide financial assistance to eligible unit owners and unit owners associations for costs incurred in the filing of the claim. And so, Mr. Chairman, I move the bill.
Thank you, Councilmember Bonds. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. If there's no objection, we'll consider the next three together: PR 24-776, PR 24-777, PR 24-778. These are nominations to the District of Columbia Housing Finance Agency Board of Directors. The first is Brian Scotty Irving, the second is Heather Howard, and the third is Stanley Jackson. I'm mindful that the first and third will be on non-consent, but I think for presentation purposes here, Councilmember Bonds should present all three. Councilmember Bonds.
All right, thank you very much. Today, we're moving the following nominations for the Housing Finance Agency Board of Directors. PR 24-776, District of Columbia Housing Finance Agency Board of Director, Brian Scotty Irving, confirmation resolution of 2022. And PR 24-777, District of Columbia Housing Finance Agency Board of Directors, Heather Howard, confirmation resolution of 2022. And PR 24-778, District of Columbia Housing Finance Agency Board of Directors, Stanley Jackson, confirmation resolution. The Housing Finance Agency is a corporate body with a legal existence separate from the district government, stimulating and expanding home ownership and rental housing opportunities for low and moderate income families. Through its multifamily division, the Housing Agency issues taxable and tax-exempt mortgage revenue bonds to lower the cost of financing affordable multifamily housing developments. It also works with the Department of Housing and Community Development to issue 4% low-income housing tax credits and invest directly in the creation of new housing units through the Housing Investment Platform. Through its single-family programs, the Housing Finance Agency administers home ownership assistance such as the Home Purchase Assistance Program, commonly known as HPAP, DC Open Doors, and the REMIT program. Our first nominee, Mr. Brian Scotty Irving, was nominated by the mayor for reappointment as a member of the agency's board of directors with experience in home building, real estate, architecture, or planning for the term to end on June 28, 2023. Mr. Irving is the owner and founder of Blue Sky Construction and Development and has served as a member of the Housing Finance Agency Board of Directors for the past 6 years. Mr. Irving has over 16 years of residential and commercial construction and development experience, and he utilizes his expertise to oversee the successful development of thousands of affordable units across the district and has secured more than 700,000 residents in this role. Our second nominee is Ms. Heather Howard. She was nominated by Mayor Bowser for reappointment as a member of the Board of Directors with expertise in home building, real estate, architecture, or planning for a term to also end on June 28, 2023. Ms. Howard is the Vice President of Development at FD Stonewater, a real estate, Mr. Chairman, I may.
Without objection.
Thank you. Stonewater, a real estate brokerage, development and investment and advisory firm. She has served as a member of the Housing Finance Agency Board of Directors since 2019. Ms. Howard has 16 years of experience as a commercial real estate developer and has managed new construction, base building renovations, and tenant improvements for more than 3 million square feet of space and totaling more than $800 million in assets. Our third nominee is Mr. Stanley Jackson. He was nominated by the mayor for reappointment as a member of the agency board of directors representing community or consumer interests for a term to end on June 28, 2023. Mr. Jackson was first appointed to the board of directors in 2012 and has served continuously since 2016. He is president and CEO of the Anacostia Economic Development Corporation, a leading and progressive DC nonprofit economic development organization. Mr. Jackson has over 3 decades of housing and economic development expertise service in key private, public, and nonprofit leadership roles. During his tenure with the district, he directed the district's participation in the development of over 6,700 units of new constructed and rehabilitated affordable housing for seniors, special needs, and very low to moderate income district residents. Mr. Chairman, the Housing Finance Agency Board of Directors is 5 members appointed by the mayor with the advice and consent of the council, and 2-year term members continue to serve until a successor has been qualified. And so, Mr. Chairman, with that, I move the legislation, the bill.
Thank you, Councilmember Bonds. Are there questions from members? Councilmember Robert White.
Thank you, Mr. Chairman. Quick question on these, following up on some thoughts raised at the breakfast meeting. Some of the nominees have, I believe, conflicts of interest. But I'm looking at the statutory qualifications. They're pretty broad, including experience in mortgage, lending, and finance, members with experience in home building, real estate, architecture, or planning, and 1 representative of community or consumer interest. With such broad qualifications, why do we have nominees who have, it seems, frequent conflicts of interest? So these seem like talented people. Certainly many of them I know and respect very much. I can't say I understand at this point why we have nominees why we select nominees with significant conflicts in that they apply for and receive HFA funds.
Mr. Chairman. Mr. Chairman.
Councilmember Bonds.
Thank you very much. Well, one of the challenges of the board is that our city is that in our city, there's a limited pool of DC residents, which is a requirement, that are experienced and qualified with those expertise that are willing to serve. One of the goals of boards and commissions appointments, if I recall from my years of working on the executive side of government, is getting individuals who are willing to serve. Now, I have spoken to some persons who have big enterprises, and you would think that they would want to and would be willing, but they're like, Anita, I'm too busy. And so I think that is one of the challenges that we're facing. And I also feel that if we are looking to individuals that will give service, we have to decide, are we going to penalize experience, professional connections, and engagement with both the industry and the community, and then say, therefore, you're not qualified because of your lifestyle on behalf of your enterprise and your community? And so that is, we have talked about these kinds of situations before, where the issue becomes, if I do this kind of work and the board that I'm asked to serve on is because I have these expertise, should I then be denied the opportunity to continue my business, my work? And so that's always going to be a big challenge that we have faced. And particularly, if I may, Mr. Chairman, particularly as we are trying to continue to grow our small business in the District of Columbia. And our small businesses do tend to be persons who have been around and who are struggling and trying to survive.
May I have 1 additional minute, Chairman?
Without objection.
I appreciate the response. And I think it's right that we don't want to penalize people for being good at what they do. It still seems though that the qualifications in the statute are broad, and I have to assume that there are people who are willing to serve. there's a notion in this city still that you have to be plugged in order to be successful. And we have to take that seriously, even when the nominees are people we like. I can't say that I know the answer to that, so I'm not sure I'm voting today. I'm not inclined to vote against the nominees. But I recognize a problem, and I'm not sure, frankly, what I'm going to do on the vote today, but also going forward. But I think there are too many talented people in this city for us to say there aren't enough interested parties, and I think we have to challenge the executive here a little bit more, so we can continue to restore faith in the process.
I agree with you, and thank you for your comments.
Thank you, Mr. Chairman. Thank you.
Thank you.
Councilman.
Thank you. Councilmember Che.
Yes, first of all, we shouldn't be talking about penalizing because to be on these boards is a privilege and there's no right to this, and so it's not a penalty. And then consistent with Councilmember White's observation about the broad-based qualifications, I would like to ask, have we looked at the potential pool of people who would meet those qualifications? And it's not just that they do this work and so therefore they shouldn't be selected. It's they do this work and they seek contracts and would be in a direct conflict of interest. And although they might recuse themselves, there might be too cozy a relationship among the other members. So I'd like to know, do we have any sense of how many people could satisfy these qualifications?
Councilmember Bonds?
No, I cannot give you an exact number of who might qualify for these. It's really bonds. It is not a contract, it's bonds. And we're talking about our multifamily, primarily our multifamily development community. And I think when we speak of that community, all of us, representing the various wards, the city may know of individuals, or at least those that have come to the surface who are doing various projects across the city. And those are the individuals who then, once they have gone through, for instance, the Housing Production Trust Fund for gap financing, then go to the Housing Finance Agency for, the appropriate bonds. There are private entities that do not go through the government sources like for gap financing that also go to the Housing Finance Agency. But I suspect that the pool of those that could serve and pass, who could serve on this board would be a fairly small subsection of our development or our business sector in the District of Columbia. Particularly when you, as my colleague has pointed out, the qualifications, it says that these are individuals with experience in home building, real estate, architecture, planning, and it pretty much is focused on the residential construction as opposed to some other construction.
Any further questions? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration? Are there three measures?
All right. Yes, they are.
Madam Secretary, are the records complete for each?
Yes, Mr. Chairman.
Madam Budget Director, do the measures fiscal impact statements comply with council requirements?
Yes, they do.
Without objection, PR 24-777 will be on the consent agenda for today's legislative meeting. And PRs 24-776 and PRs 24-778 will be on the non-consent agenda.
Could you repeat that which ones are or are not?
24-776 concerning Brian Scotty Irving will be on non-consent. PR 24-777 concerning Heather Howard will be on consent. PR 24-778 concerning Stanley Jackson will be on non-consent.
Thank you.
That's consistent with how the agenda was circulated last night. We will turn now to three measures that were reported out of the Committee on Judiciary and Public Safety chaired by Councilmember Charles Allen. The first is Bill 24-416 Revised Criminal Code Act of 2022. Councilmember Allen indicated to me before the meeting today that he's tried to condense his statement to 3 minutes, but it may be longer. And as we know, this is quite a comprehensive bill. So there's no objection. He'll have additional time. Mr. Allen.
Thank you very much, Mr. Chairman, and to my colleagues. I'll do my best to hit 3 minutes. Thank you. Bill 24-416, the Revised Criminal Code Act of 2022 was introduced on October 1st, 2021 by you with the request of the Criminal Code Reform Commission. The bill was referred to the committee on October 5th, 2021, and the committee held 3 public hearings on the bill, the first on November 4th, 2021, the second on December 2nd, and the third on December 16th. It was then approved unanimously at the committee's additional meeting on October 26th of this year. The Revised Criminal Code Act of 2022 is a monumental, consequential piece of legislation that overhauls, modernizes, and organizes the district's entire criminal code. It is the culmination of almost 16 years of planning and hard work, more than 50 in-depth working sessions between representatives of stakeholders in the district's criminal justice system, nearly 20 hours of council hearings, and almost 2 years worth of work in the committee. There has not been a comprehensive rewrite or reorganization of our criminal laws since 1901, more than 120 years ago. Since then, Congress and many different councils have passed different laws and created new crimes over time, but a comprehensive modernization of our criminal code, an effort that many other states have already taken, has never occurred here in the district. As a result, our criminal laws are a mess and have been ranked among the worst in the country, largely because we have never undergone a revision process like this. We have overlapping charges, inconsistent or missing definitions and elements, and outdated terminology. The punishments often don't fit the crime. They're unclear to everyone, from victims and survivors struggling in the aftermath of violence, to the defendants facing a complex layer of charges, to the prosecutors and lawyers who represent the various parties, and to the judges and juries who have to make conviction and sentencing decisions. They're also extreme in places and out of touch with our modern values. Since 2006, an independent agency, the Criminal Code Reform Commission, and its predecessor, the Criminal Code Revision Project, has taken a comprehensive and informed look at best practices across the country and within the district to draft a modernized criminal code, removed from the day-to-day headlines, but still reflective of the unique social fabric of the district. The bill we have before us today is largely the work produced by the commission and is the product of countless meetings and conversations, hard collaboration and compromise, and thoughtful engagement by a wide range of stakeholders, all of which might disagree with a particular element of the total package, but recommend moving the package forward nonetheless and recognize the immense value and importance of doing so. I'll now briefly highlight where the committee print diverges from the introduced version of the bill, although I will not be able to cover all 450 pages of the bill in my remaining time. The recommended maximum penalties are increased for several of our most serious crimes: burglary, robbery, and carjacking, especially when a crime involves a firearm or a weapon. Carjacking will remain its own offense with different gradations of the crime. The right to a jury trial for all misdemeanors that carry jail time is now phased in over several years, starting in 2025 and continuing through 2030, with multiple independent analyses conducted to track the impacts on our courts as this right is returned. The change would bring DC in line with the majority of states who provide for jury trials and most charges that come with jail time. Mandatory minimums for nearly all revised crimes have been eliminated with the exception of first-degree murder. And a mechanism for second look resentencing is now available for those who committed a crime when they were 25 years old or older and have served a minimum of 20 years imprisonment, creating one avenue for revisiting extreme sentences given the lack of meaningful parole, pardon, or clemency in the district. Today, we have the opportunity to take a monumental step forward to a much improved criminal code and to do so in the same deliberate and thoughtful manner as this bill was crafted by the Criminal Code Reform Commission. I urge my colleagues to recognize that this is not meant to be the perfect solution in everyone's view, but a strong and important step forward that includes years of compromise and collaboration from all parties involved. Before I move on, I do have to especially thank the Criminal Code Reform Commission, the Office of the Attorney General, the United States Attorney's Office, the Public Defender Service, and the 2 law school members of the CCRC's advisory group, Don Brayman and Paul Butler. They have been critical to this project over the years and have made this moment possible. I also want to thank the mayor, the city administrator, and MPD chief for their feedback and collaboration in this final product. And of course, something this large and consequential doesn't happen without our staff. And I want to specifically thank my team for their outstanding work and dedication for this years-long project. Thank you, Mr. Chairman, and I'd like to request this measure be placed on the agenda for our legislative meeting to follow.
Thank you, Councilmember Allen. Are there questions from members?
Mr. Chairman.
Mr. McDuffie?
Thank you, Mr. Allen, to you and your team. Having chaired the Judiciary Committee, I know how much work goes into this and in the work of the Criminal Code Reform Commission. They've been hard at work laboring over this for some time, so I want to thank them for their efforts as well and all the other stakeholders who contributed. I do want to ask, I know there was some, just in preparing for this, there was a statement by the U.S. Attorney's Office where they're essentially, and you could correct me, I'm paraphrasing obviously, but they said they supported the markup of this bill, but had outstanding concerns. At our Mayor Council breakfast last week, the Chief of Police also alluded to having outstanding concerns. Can you just briefly articulate what Matt Graves and his office's outstanding concerns are, if they still exist, or whether you have had subsequent conversations after they made that statement and those have been resolved? I know you've worked extensively with them throughout this process and have addressed some of the concerns that were outlined in their testimony before your committee, but have there been subsequent conversations between the last statement that they made and today's markup where additional concerns that they said were outstanding have been resolved to this point?
Thank you. And I'll add to that, of course, the Public Defender Service also sent us all a letter saying that they have highlighted concerns. The ACLU has sent us a letter.
I'm just asking about the U.S. Attorney's Office at this point.
Sure, I just want to make sure it's clear that this will never satisfy every single person for every single issue, that there will be concerns cited by all stakeholders. I do not dare speak for the U.S. Attorney's Office or the Metropolitan Police Department. I can tell you, though, that I was speaking over the weekend several times with our U.S. Attorney, Matt Graves. I don't think that the final product for any stakeholder, be that USAO, MPD, PDS, anybody, is going to reflect every single concern or issue. But they have said, we believe it should move forward to markup. And I think they're going to continue to highlight specific concerns that they may have.
I agree with you and really appreciate all the varying interests that are at stake and all the folks who, and I had a list of folks I was going to ask you about, including PDS. So I hadn't gotten there yet. I only got 38 seconds left, but I wanted to know what are the specifics that they say have not yet been addressed? Because they didn't mention it in their statement, but they alluded to it in their statement that there were things that still have not been addressed by this version that we're considering today.
Again, I don't think that I don't want to speak for any of the parties. I think they need to be able to, they can and have represented themselves. I think if you're asking me to generalize something, the U.S. Attorney, for example, has highlighted concerns around whether or not penalties should be higher than the increases we are making. They've highlighted concerns over, as we implement jury demandability for individuals facing jail time for misdemeanors, not a concern around should we or should we not do it, but how would it be done in a way to be successful? It's part of the reason why, using that example, we extended the amount of time it takes to expand that right to a jury. Again, this is something we used to do into the 90s. We also add the implementation over multiple phases. And then I also build in independent evaluations at each phase so that we can monitor the impacts on the courts, such as impacts on juries, time to trial, things like that.
And that's one of the reasons why I think you made some modifications about how long it takes for jury demandability and the process for that to be implemented over the course of some time.
Absolutely. I just want to be very careful that I don't want it to be represented that every party out there is 100% satisfied on every issue. But I don't think that should also be the expectation, because they never will be.
Mr. Chairman, just if I could, I know I'm over my time, but this, again, over 400 pages. I wanted to ask about both the DC Office of the Attorney General and the Public Defender Service. The DC Office of the Attorney General, are there any outstanding concerns that our DC OAG office has with this bill that is before us today?
I think that there will be, out of 450 pages, there will be something in there that the Attorney General would want to see done differently, perhaps. They have, however, given their enthusiastic support that this should move forward and support for the package moving forward.
And then the Public Defender Services, just briefly, if you can speak to anything that you're aware of that they've had any issues with that linger at this point with this version.
Sure. You may not be surprised by this, that in the same way that the U.S. Attorney's Office has some concerns around whether the increases we made in penalties should go further, PDS is concerned that increases in penalties are too much and should not go that far. So again, I think that one of the big takeaways here, for those that practice in this space know, our entire criminal justice system is based on an adversarial nature, where opposing parties are using the same law to argue their cases. I think it says a lot, and it's a testament, frankly, to the collaboration of all these parties, that adversarial nature actually brought everyone to the table to work hard
So,
on
Ms. Allen,
compromise
I'm
and
actually,
collaboration.
I'm actually agreeing with you, and I don't want to
Yeah.
cut you off, but I was asking those questions to make a similar case for what you're saying, in that this is a process that is least likely to achieve 100% consensus, and that it's in a process that's been labored with over the period of time. It is a very extensive bill before us today, but I also think it speaks to how challenging our criminal justice system is to make sure that we are doing justice. And I feel like all the parties weighed in throughout this process, and I think the public will have to make a determination about whether or not they think this council is doing the right thing. I do think that we've been thoughtful about how we've approached this. I'm not a member of the Judiciary Committee, but I've spent some time with my team and I trying to cover this, and I may have some questions between now and second reading. Thank you, Mr. Chairman.
Thank you.
Thank you, Councilmember. If people could be mindful of the time, please. Councilmember Henderson and then Councilmember Silverman.
Thank you, Mr. Chairman. I just have a couple of questions, Councilmember Allen. So the committee print drafts the kidnapping statute. It makes a change to require substantial confinement, which would include very brief or trivial detentions. My question is, what do we mean by substantial? And let me explain why. Last year, we had a couple of incidents where someone jumped into a running car and took off. While there was no driver, there were children in the back seat. And I believe in all those cases, the car was soon abandoned and the children were unharmed. However, with this new requirement for substantial confinement mean that charging attorneys would not be able to include kidnapping on top of carjacking as well.
I appreciate the question. So the current statute for the offense of kidnapping covers all restrictions of movement. And so what the CCRC proposed was distinguishing between when an individual is essentially confined or restrained criminally versus when there is movement involved. And so what it does is it splits into two different spaces, a new offense of criminal restraint and then kidnapping. And so the obviously, it's very difficult to legislate for every fact pattern that might be presented. And I want to be
Right,
very
yes.
careful about not trying to make statements around different hypotheticals or fact patterns.
Right.
But in an event that you are describing where there is just a individual where there is criminal restraint, that would have a certain charge.
Okay.
If there is driving off and substantial movement of someone, that I think you would probably find in most cases following fact patterns. And again, I can't interpret the law from a fact pattern for every unique case.
Right. I totally
But in many of
understand.
those cases, that would be kidnapping.
Okay, these are questions I think more for the record to sort of get on the clarification. The next one I wanted to ask, the committee print maintains the current existing law as it pertains to rioting language as opposed to the language proposed by the commission. Not many people focus on rioting provisions in general, but this did come up in the summer of 2020. In particular, at what point does a protest become a riot and who gets to decide? I think the current language in our code now is vague-esque. And so I'm just curious in terms of why the committee chose not to go with the commission's recommended language, which I thought was a bit clear.
So as I mentioned, the product that was moved forward to committee level is the product of a lot of collaboration and compromise. So this is an element that we worked on with the executive and was a direct request from the executive branch around trying to find some compromises. When we did have a hearing on the legislation related to updating our rioting, we heard from a lot of business leaders and residents concerned with the proposed amendments that we had in separate standalone legislation when we had the Rioting Modernization Amendment Act hearing. So for this bill, we're keeping the current law as is for the time being. But of course, that rewriting of the writing code could also be reintroduced and represented as a standalone bill.
Okay, thank you. Mr. Chairman, can I have some more time?
Without objection, but please watch the clock.
Okay, sorry. It's a long bill. It's the whole criminal code, and I'm not on the committee. I wanted to ask how the committee determined how much to increase the maximums for carjacking and bulk burglary. I recognize, I read the committee report, and shout out to your team and your staff for a very thorough, I think, discussion and analysis. But my question more or less is around how did you all determine how many years by which to increase those maximums for those particular charges?
Thanks. Looking at them, in many cases, we attempted to use the schedule that was created through the CCRC process, but also in hearing feedback in our hearings and meetings with stakeholders, did not feel that the proposed penalties for those offenses accounted for the harm that was involved. So similarly, in the way that my recommendation was that carjacking should not be treated underneath as a part of robbery, but should be its own standalone offense. I think that the harm and threat posed during a carjacking is different and unique than in other forms of robbery, even though that's how other states do it. So we maintain that. Working through the penalty phases, we looked through the different classifications of the RCCA's penalty classifications, tried to tailor what we thought was the appropriate maximum. Also looked at Superior Court current sentencing so that you would have the sentencing, the penalties would line up in many cases, fairly equivalent with the ways in which sentencing is going on. So for example, within carjacking, it is approximately 98% of sentencing would fall within the penalty range that is outlined here. And so trying to keep an eye towards both how are our courts currently acting and treating, where do we feel like based on feedback, we think that the maximum penalty should land is what helped determine those recommendations.
Great. And finally, I just wanted to express my appreciation to the committee for listening to the feedback from the hearing as it pertains to the mistake of age proposal and removing that, which I also had concerns in terms of, in particular, how it impact Black children who were victims of sexual violence or crime. Thank you.
Thank you.
Thank you, Councilmember Henderson. Councilmember Silverman.
Yes, thank you, Mr. Chairman. So let me start off by saying, Councilmember Allen, that I know that this is, the culmination of probably one of the most ambitious pieces of legislation that I've seen in my years on the council, and probably one of the biggest things done in the home rule era. So first, I do want to express my appreciation for the efforts of many people who got us to this point. Councilmember Allen, thank you, and the Judiciary Committee. Actually, last week in the council breakfast, it was mentioned many times how you have thoughtfully and painstakingly listened to many of the people involved to get to where we are today. And thank you to the members of the Criminal Code Reform Commission and the countless experts. I know Don Brayman, but prosecutors, defenders, police, professors, and academics who drafted and debated this so much. Also, Mr. Chairman, I believe you moved the legislation for the Criminal Code Commission. So thank you for initiating this project. Okay, I do have a question. So the bill states repeatedly that a defense is available to a person who is charged for causing an injury in the course of a quote lawful medical procedure. So for example, if a doctor performs a lawful medical procedure with the patient's consent, the doctor has a defense to a criminal charge of assault. I wanted to hear from you, Councilmember Allen, how this changes if, given what is going on, what might happen, what has happened at the Supreme Court with abortion, and what might happen, let's say, with contraception and gender affirming care. Certainly the council has done great work to protect patients and healthcare providers in anticipation of further horrific laws that Republican congressmen have promised to put in place if there is a bad outcome in November. But let me ask you, Councilmember Allen, what would it mean for this lawful medical procedure defense if abortion or other health care is made unlawful by a Republican Congress?
Thank you. And even though we're at time, Mr. Chairman, if it's okay to have a little extra time to answer the question. I definitely appreciate the question. And I think it's probably on a lot of our minds around in what ways do our district laws work to make sure we're safeguarding our values. It is somewhat difficult to anticipate what a future Congress or court might decide, and in what ways will the code that we write be able to protect and around the lawful defense. I'd love to work with you a little bit more on this to make sure that we're trying to think through in what ways do we use the code, I'll say proactively, to anticipate what might happen in 2024. But one piece I would acknowledge is that because the revised criminal code has a 3-year delay in application, applicability date is in 2025, but the scenario that's being played out is potentially 2024. One space that we might also want to work again, because collaboration is in the middle name of this bill, is to reach out to my colleague who also has the Protecting Health Professionals Providing Reproductive Health Care Amendment Act of 2022 that I believe shall be moving forward. And that might also have a quicker applicability date and might be one of the ways that we can work together between first and second reading on this bill to think about whether or which might be the right vehicle to make sure that we have the language in a way that I think protects our values.
That'd be great. I'd love to work with you, Councilmember Allen, and I know I'm over time. So I appreciate your collaboration on this. Thank you so much, Mr. Chairman, and thank you, Councilmember Allen.
Thank you.
Thank you, Councilmember Silverman. Further questions? Councilmember Allen, some of the discussion incented me to ask you about sentencing. I think it was when there was some discussion about whether there should be higher sentences than what's in the bill. When you got reaction to the bill as introduced and the commission's recommendations, and you started working through the different penalties, and there was suggestion for higher sentences or lower sentences, how closely did you look at what the sentencing guidelines are today? How closely did you look at what the sentences, average sentences or predominant sentences are for that offense in the court?
Very closely. So not only did we do that, the CCRC, of course, did that in their own crafting. But as our due diligence and hearing feedback, we also took a look at that. And so I think that looking at what we see our courts apply is absolutely part of a driver in helping make that final decision. I think recognizing how do we distinguish between the inherent harm that can come from armed versus unarmed offenses also helps inform where we made recommendations. And so overall, I think it's representative of the feedback that we got, but also to your point, taking a look at the sentencing guidelines as well as the actual sentencing coming out of Superior Court to try to navigate that. And then, of course, because we are creating gradations where in most cases there are none, then creating gradations between third, second, and first degree.
Thank you. If there are no further questions on this? Or are there? There are no further questions on this. Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is the bill subject to appropriation
Yes, it is.
over time, correct?
Correct. So the cost is 4.7 million in 2023 and 52.9 million over the financial plan.
And a lot of that is related to what I would call one-time funding, such as training.
Correct. So the bulk of the cost is training costs at MPD. So approximately 40 million of the cost is at MPD for the cost of training officers on the revisions.
Thank you. Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next item is Bill 24-450, Uniform Electronic Wills Amendment Act of 2022. Councilmember Allen.
Thank you very much, Mr. Chairman. Bill 24-450 is the Uniform Electronic Wills Amendment Act of 2022. It was introduced on October 18th, 2021 by you at the request of the Uniform Law Commission. It was referred to the committee on November 2nd, 2021, and the committee held a public hearing on March 8th, 2022. The bill is unanimously approved at the committee's additional meeting on October 26th. The committee print would enact the Uniform Electronic Wills Act, which would allow for the execution and recognition of electronic wills. Current law requires a will to be in writing, signed, and declared to be the person's will in the presence of two or more witnesses. Such rigid requirements are outdated today because people are allowed to execute other estate planning documents, such as beneficiary designation forms and powers of attorney electronically. This authority is similar to that included in the council's emergency and temporary legislation passed in response to the COVID-19 pandemic. Committee print would also allow a court to remove a guardian or conservator of a person for abuse, neglect, or financial exploitation. These important provisions have their origin in Bill 24-854, the Guardian Removal Amendment Act of 2022, which was introduced as a standalone bill by Councilmember Bonds alongside Councilmembers Gray, Henderson, Lewis George, McDuffie, Pinto, and Silverman on June 13th, 2022. If found to have engaged in abuse, neglect, or financial exploitation, a guardian or conservator would be prohibited from serving in the same capacity for a 5-year period and until they can demonstrate rehabilitation to the court's satisfaction. Lastly, the committee print permits the court to report a guardian or conservator removed for abuse, neglect, or financial exploitation to a professional licensing authority if the guardian or conservator holds a professional license. Thank you, Mr. Chairman. I request that this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The last item from the committee is Bill 24-561, Homeland Security Fusion Center and Law Enforcement Authority Amendment Act of 2022. Councilmember Allen.
Thank you very much, Mr. Chairman. Bill 24-561, the Homeland Security Fusion Center and Law Enforcement Authority Amendment Act of 2022 was introduced on December 10th, 2021 by you at the request of Mayor Bowser. It was referred to the committee on December 21st, 2021, and the committee held a public hearing on March 14th, 2022. The bill is unanimously approved at the committee's additional meeting on October 21st. The measure is similar to emergency and temporary measures passed unanimously by the council earlier this council period. The committee print would statutorily recognize and set forth the mission of the Homeland Security and Emergency Management Agency's Fusion Center, which serves as a coordinating body in the district for the receipt, analysis, gathering, and sharing of sensitive threat-related information between local, state, and federal partners. The print would also designate the Fusion Center as a law enforcement agency solely for the purpose of receiving intelligence. Given that the Fusion Center is currently housed in HCMA and not in a law enforcement agency, it has experienced difficulties in being able to receive intelligence from other Fusion Centers and law enforcement agencies across the country. These difficulties resurfaced, for example, during the investigation into the events that occurred in the January 6th, 2021 at U.S. Capitol. However, in granting HCMA this authority, the print would also require the Fusion Center to foster transparency by submitting an annual report to the Council Committee with jurisdiction over Homeland Security matters and provide information on its operations during the prior year. This provision addresses potential concerns over the opacity of some Fusion Centers operations. Thank you, Mr. Chairman. I'd like to request this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember Allen. Are there questions from members? Councilmember Lewis George, are you asking to be recognized?
Yes.
Please.
Thank you. I think you were addressing this towards the end there, Charles, regarding there were some flags in the core report, which was the Fusion Centers rely heavily on surveillance technology and surveillance intelligence sharing across state lines. And I know there have been conversations previously on legislation that would provide sort of greater community transparency and oversight of sort of law enforcement technology. I think the core report flags some Fusion Centers have manipulated their intelligence in a sort of targeting mostly, lots of people of color. And so I just wanted to see what conversations, where the conversations are on that sort of legislation around transparency and accountability. And did the committee consider adding any of the sorts of checks and balances in the process of codifying the HCMA Fusion Center?
Thanks. I think that you are referring to perhaps there's a separate bill related to overall MPD surveillance that has been kind of talked about and worked on, which is separate from this. And because that's MPD, that would not be in this space. This is mostly focused on HCMA's ability to receive intelligence. So for example, as we looked at January 6th, as we looked at other events, HCMA found itself in a position of being unable to, because they are not a quote unquote designated law enforcement entity, to be able to receive information from other spaces. So as the Fusion Center is there to help pull together this different information to try to help make sense of it and identify threats, they, in some cases, I think relied on some professional relationships, but they did not have the ability to actually receive that. And that is very distinctly different than the other element, which I think you're referring to, which is a larger effort at overall transparency around surveillance tools that are used locally within the police department. So this does not touch that. I will add, though, one of the things that we thought was important is making sure that you have the type of transparency and reporting. So that's why we added that in, so that there is an annual, very intentional type of reporting, so that I think that one of the concerns around Fusion Centers overall is that oftentimes the nature of security and threat assessments means that it's a black box that's hard to understand what's going on inside of it. And so having that type of reporting and transparency can be one of the ways that we try to help address that.
Okay. And who will that report go to? Will the council have access to that report?
It goes, the way that it's structured is that it would go to the council committee with oversight over the Homeland Security matters. So at least as it's currently constructed, that would be to the Council on Judiciary and Public Safety.
Okay.
But of course, once that's received, that's something that all council has access to.
Okay.
In the same way, like a report that might go to the Committee on Health on a healthcare issue,
Right.
but all of us have access to that.
Okay. Just want to make sure the
Yep.
council is receiving it. Okay.
Yep.
Thank you.
Thank you, Councilmember Lewis George. Any further questions? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next 7 measures were reported out of the Committee on Business and Economic Development, chaired by Councilmember Kenya McDuffie. The first is Bill 24-798, New Market Tax Credit Real Property Tax Exemption Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-798 was introduced on April 27, 2022 by me and referred to the Committee on Business and Economic Development on May 3rd, 2022. The committee held a public hearing on this bill on June 16th of this year and a markup on October 19th. This measure would provide a real property tax exemption for real property belonging to qualified active low-income community business that participate in transactions qualifying for the new markets tax credit. Would also streamline the real property tax exemption application timeline and process by which the Office of Tax Revenue must review real property tax exemption applications for these applicants and communicate its decision with applicants. The need for this bill arose during a February 22nd hearing the committee held, in which a consortium of local nonprofit housing organizations testified to the obstacles their members face when trying to secure financing for much needed projects in low-income communities for the District of Columbia. Without this bill, several worthwhile affordable housing, workforce development projects may not come to fruition. With that, I'd ask for this measure to be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember McDuffie. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 24-823, 206 Elm Street Northwest Real Property Tax Abatement Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-823 was introduced on May 23rd, 2022 by Councilmember Brianna Doe and referred to the Committee on Business and Economic Development on June 6, 2022. The committee held a public hearing on this bill on September 21st and a markup on October 19th. During the fiscal year 2023 budget process, the council set aside $30,000 to fund this measure, which will provide a real property tax abatement for property located at 206 Elm Street Northwest in Ward 1 during tax year 2023. With that, I would ask that the measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember McDuffie. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Mr.
Yes, it
Chairman,
is.
Let me just ask the questions. Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
I'll come back to you in a second. Councilmember Bonds?
Yes, thank you, Chairman. I just had a question about the set aside, the $30,000 and wondered, by doing this, we're helping, but we're only helping with the current arrears and the situation. I wonder, is the owner of the property going to have the ability to go forward and to take care of their financial obligations into the future? Or are we just delaying the inevitable? I'm just curious.
That's the hope, and that's what she testified to, that she should be able to. We asked those questions, and obviously this tax abatement is in recognition of the hardship that she's faced. And the reality is there are lots of other people out there who face similar hardships. So while this is specific to her, and that we hope that she's will be able to reconcile the challenges that she faces, we recognize that there needs to be more done to address this more broadly. But she did testify that the amount that we had set aside should suffice.
I appreciate that response because, as you said, there are a number of households that face this kind of hardship. And with the economy as it is, there may be more. And I think we need to think about what is a good tool that can help them all. Thank you.
Thank you, Councilmember Bonds. Madam Budget Director, there's a fiscal cost of the bill, which is in the budget. It's about $30,000.
Correct. And we took care of the tax expenditure when we passed the FY23 budget.
So the bill's funded.
Correct,
Council's already, in a sense, voted on this.
correct,
There is a tax abatement financial analysis, or TAFA.
correct,
The TAFA is what we call negative,
correct. It says that the abatement is not necessary.
and that's why this will be on non-consent.
Correct.
Because our rules require that. I asked the clearance questions. This measure will be placed on the non-consent agenda for today's legislative meeting. Bill 24-851, State Small Business Credit Initiative Venture Capital Program Grant Making Establishment Act of 2022. Councilmember McDuffie.
Thank you again, Mr. Chairman. This measure was introduced on June 9th, 2022 by you at the request of the mayor and referred to the Committee on Business and Economic Development on June 28th, 2022. The committee held a public hearing on this measure on October 5th, 2022, and a markup on October 9th of this year. The council recently approved the emergency and temporary versions of this bill, which would establish a local venture capital program here in the District of Columbia, funded by the United States Department of Treasury, and in accordance with that agency's guidelines. The measure would also amend legislation giving the Deputy Mayor for Planning and Economic Development limited grant-making authority to allow the office to provide grants to a local program administrator for the purpose of making long-term investments in local district-based businesses. With that, I'd ask the measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember McDuffie. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. Bill 24-894, Whitman Walker Entity at St. Elizabeth's Tax Rebate Amendment Act of 2022. Councilmember McDuffie.
Thank you. Bill 24-894 was introduced on June 27, 2022 by Council Members Gray and Trayon White and referred to the Committee on Business and Economic Development on July 12, 2022. The committee held a public hearing on this measure on October 5th and a markup on October 19th. If approved, the bill would support the Whitman Walker Clinic's expansion to the St. Elizabeth's campus through the provision of a tax rebate of the organization's real property taxes at its new Max Robinson Center in Ward 8 for up to 25 years, so long as the entities maintain an active lease for the property, have paid the taxes on the property, and utilize the space for the provision of health-related services. With that, I ask that the measure be added to the agenda for the legislative meeting to follow.
Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Is there a fiscal impact to the bill?
Yes, it is 1.3 million in FY 23 and 5.5 million over the plan. And we have not accounted for this in any approved budget and financial
So
plan.
this is subject to
subject.
appropriation.
Correct.
And this is a rebate as in a refund or an abatement? as
It
going
is a
forward?
rebate. So I guess it's for the Whitman Walker leases the space in a privately owned building. So they would be rebated what they pay or what the owner pays.
And there is a TAF, a negative TAF.
Correct. Correct.
This measure will be placed on the non-consent agenda for today's legislative meeting. Bill 24-935, UDC Leased Property Tax Abatement Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-935 was introduced on July 11, 2022 by council members Robert White, Bonds, Lewis George, Pinto, Henderson, Silverman, Nadeau, Allen, Che, and Chairman Mendelson, and referred to the committee on July 12, 2022. The committee held a hearing on the measure on October 5th and a markup on October 19th of this year. During its fiscal year 2023 budget deliberations, the council set aside funds to support this tax rebate for property leased by the University District of Columbia at 4225 Connecticut Avenue Northwest, so long as the university continues to lease the property and use it for educational purposes. There is a negative top associated with this measure, and so I ask that this be placed on the non-consent agenda of the legislative meeting to follow.
Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Funded in the budget?
Correct. It was funded in the FY 23 budget and financial plan. The tax expenditure is 152,000 in FY 23 and 620,000 over the 4-year plan.
Thank you. This measure will be placed on the non-consent agenda for today's legislative meeting. Bill 24-940, again, Bill 24-940, Performing Arts Promotion Tax Rebate Clarification Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-940, the Performing Arts Promotion Tax Rebate Clarification Amendment Act of 2022 was introduced on July 12th, 2022 by Councilmember Robert White and referred to the Committee on Business and Economic Development on September 20th, 2022. The committee held a public hearing on the measure on October 5th and markup on October 19th this year. The council previously approved the emergency and temporary versions of this measure, which would provide tax relief to eligible entertainment venues during a public health emergency. The bill would also give authority to the Office of Cable Television, Film, Music, and Entertainment to review and process applications and certify to the Office of Tax and Revenue which companies are eligible for the tax rebate. With that, I ask for the measure to be placed on the consent agenda of the legislative meeting to follow.
Thank you, Councilmember McDuffie. Are there questions? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. PR 24-927, Mundo Verde Bilingual Public Charter School Revenue Bonds Project Approval Resolution Act of, can't say Project Approval Resolution Act, Resolution of 2022. Councilmember McDuffie.
Thank you. This measure was introduced on September 16th, 2022 by Chairman Mendelson at the request of the mayor. The proposed resolution was referred to the Committee on Business and Economic Development on September 20th, 2022. The committee held a public hearing on the measure on October 5th and a markup on October 19th of this year. If approved, the legislation would allow the District of Columbia to issue up to $60 million in tax exempt bonds, notes, or other obligations to help Mundo Verde Bilingual Public Charter School refinance bonds they received in 2014 to renovate its campus at 44 P Street Northwest. Acquire a facility the school currently leases at 4401 H Street Northeast for use as a charter school campus, as well as acquire and construct a new campus on a parcel at 817 Barnum Street Northeast and finance the issuance and other costs associated with this total project. This project complies with Section 490 of the District of Columbia Home Rule Act and would not be of any recourse to the District of Columbia. And with that, I would ask that this measure be placed on the consent agenda for the legislative meeting to follow.
Thank you, Councilmember McDuffie. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next bill was reported out of the Committee on Government Operations and Facilities, chaired by Councilmember Robert White. Bill 24-509, Inspector General Oversight Consistency Amendment Act of 2022. Councilmember White.
Thank you, Mr. Chairman. Bill 24-509, the Inspector General Oversight Consistency Amendment Act of 2022 was introduced on November 10th, 2021 by myself, as well as council members Bonds, Lewis George, Nadeau, McDuffie, Silverman, Shea, and Pinto. This legislation is the permanent version of identical emergency and temporary legislation that has been in effect since last November. While this bill is short and simple, it is critically important to the council's broader work to ensure adequate oversight of the District of Columbia Housing Authority, or DCHA. We all saw the recently released report from the Federal Department of Housing and Urban Development highlighting the dramatic decline and dysfunction at DCHA. The report made clear what we have seen for years, that DCHA is failing in almost every aspect of its operations and requires substantial reform. That's why just earlier this week, the council passed emergency legislation to bring additional transparency and oversight to DCHA. While small, this bill is another step in the same direction. Specifically, this legislation will ensure that the Office of the Inspector General, or OIG, can continue to independently investigate the wide-ranging issues at DCHA without requiring a prior request by the council. This issue arose late last year when the OIG notified the council that it needed to investigate serious allegations at DCHA, but that it was being stymied by DCHA's leadership in part due to a quirk in the law. Through legislation passed by the council in 1999, the council clarified the OIG's authority to independently investigate all dependent and independent agencies other than the council and the courts. All agencies, that is, except for DCHA, which was specially insulated from that oversight in a second bill passed that same year. In order to undertake investigations and reviews of DCHA, the OIG first had to receive a request from the council. Unfortunately, seeking a request of the council to initiate an investigation put at risk OIG's compliance with legally mandated auditing and investigation standards. Specifically, a prior council request impeded on the confidentiality, independence, and timing of OIG's work. In addition, it was unclear what a request of the council meant in this context. The result of that confusion was a series of letters from the Committee on Housing and Executive Administration and various council members requesting OIG investigations of DCHA and varying scope and duration. This bill will permanently remove that barrier to the OIG's work and allow it to continue its ongoing investigations. While this bill is critically important, it is obvious to me that more needs to be done to bring DCHA back from the brink and ensure our residents are receiving the dignified and safe housing they deserve. I look forward to working with the Housing Committee on further reform. Thank you, Mr. Chairman.
Thank you, Councilmember White. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be placed on the consent agenda for today's legislative meeting. The next measure was reported out of the Committee on Transportation and the Environment, chaired by Councilmember Mary Che. Bill 24-837, Ignition Interlock System Program Amendment Act of 2022. Councilmember Che.
Yes, thank you, Mr. Chairman. Today I'm moving the Ignition Interlock System Program Amendment Act of 2022, which was introduced by you, Mr. Chairman, on behalf of the mayor this past June and was marked up by the Committee on Transportation and the Environment on October 21st, 2022. Ignition interlock systems, which prevent a car from starting until the driver provides a breath alcohol concentration, or BAC test, below a set level, have been shown to reduce drunk driving recidivism by as much as 65%. This bill expands and strengthens the district's interlock program in two ways. First, the bill corrects the discrepancy under current law that prevents the DMV from requiring district licensees to enroll in the program if they commit a drunk driving offense in a foreign country or on a military base. By slightly expanding the definition of covered offenses under the law, the bill allows the DMV to require the same thing from a district licensee who drives drunk in Canada, for example, as one who drives drunk in Maryland. Second, the bill requires anyone who refuses to submit specimens for chemical testing as required by law to enroll in the program. Under current law, a person who refuses to submit to a breathalyzer test after a drunk driving arrest has his or her license revoked for 1 year. This bill allows such a driver to keep her license as long as she enrolls in the program. The committee believes this is a common sense improvement that will increase traffic safety while shifting away from punitive license revocations. And so I move the bill, Mr. Chairman, and ask that it be placed on the consent calendar.
Thank you, Councilmember Che. Are there questions from members? Madam Assistant General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Yes, it is.
Madam Budget Director, does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
Without objection, this measure will be on the consent agenda for today's legislative meeting. That's going to conclude the business for this committee, of the whole meeting. The next regularly scheduled committee, of the whole meeting is November 15th. Same place and same time. We will begin the legislative meeting in 10 minutes. That would be 2:35. The time is now 2:25 in the afternoon, and this meeting is adjourned. We're going to reconvene in about 1 minute. I'm calling to order this meeting. This is a regular meeting of the Council of the District of Columbia. I'm Tom Mendelson, Chairman of the Council. Today is Tuesday, November 1st, 2022. The time is 2:48 in the afternoon. This is our 38th legislative meeting of Council Period 24. And this meeting is being conducted or held in the room 500 of the John A. Wilson Building, the council chambers, but also is being participated in somewhat hybrid, as in at least one member is participating virtually. This meeting is being broadcast live via the Zoom video conference broadcast platform on council channel, cable channel 13, and on the council's website, www.dccouncil.gov. We always begin our legislative meetings with a moment of silence for reflection. I would ask that everyone respect this, and then we'll have a roll call. Madam Secretary, would you call the roll?
Councilmember Allen,
Here.
Councilmember Bonds. Councilmember Bonds, Councilmember Che. Councilmember Che, Councilmember Gray. Councilmember Gray. Councilmember Henderson. Here. Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Chairman Mendelson.
Present.
Councilmember Nadeau.
Here.
Councilmember Pinto.
Present.
Councilmember Silverman.
Present.
Councilmember Robert White.
Present.
Councilmember Trayon White. Councilmember Trayon White. Mr. Chairman, you have a quorum.
Thank you. We have the Secretary's report of committee filings. I'm going to recognize the Chair Pro Tem, Mr. McDuffie.
Thank you, Mr. Chairman. I'm going to move to waive the reading of the Secretary's report.
I'm going to motion to waive the reading of the Secretary's report. Is there discussion on the motion? All those in favor by voice vote say aye. Aye.
Aye.
Opposed? I don't see or hear any no votes. The motion carries unanimously. We have the Secretary's report of introductions. Again, I'm going to recognize the Chair Pro Tem, Mr. McDuffie.
And I'm going to move the reading of the Secretary's report of introductions.
Is there discussion? Again, by voice vote on the motion to waive the reading. All those in favor say aye. Aye.
Aye.
Aye.
Are there any no votes? The ayes have it unanimously. We have the consent agenda. Are there any changes to the consent agenda?
Chairman,
Councilmember Louis George.
Chairman, I would like to withdraw the Daniel Smith ceremonial recognition resolution in 2022 to make edits. That's it.
Your intention is to refile it?
Correct. Correct.
Thank you. Are there any other changes? We'll have a roll call vote. The vote is on the consent agenda as amended by removing that one ceremonial resolution. Madam Secretary, would you call the roll?
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Member McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Member Silverman votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The consent agenda is approved unanimously. We will turn to the non-consent agenda. On page 7, we have the Bedbug Control Act of 2022, Bill 24-142. So moved. There are 2 amendments. One was circulated by Councilmember Nadeau and is linked to the agenda. Councilmember Nadeau.
Thank you, Chairman. In 2019, I introduced the Bedbug Control Act in part to ensure that prospective tenants knew about bed bugs in adjoining units before moving in. Last year, Councilmember Gray introduced an updated version of my bill. The Health Committee print of this legislation, like the version I introduced in 2019, ensured that tenants would know about bedbug infestations in units other than their own before they signed a lease. More specifically, the health print required the disclosure of an entire building's 10-month infestation history. There were some changes made in the cow print, and so today I am moving an amendment to better align the engrossment with the intent of the Committee on Health. Under the amendment, landlords would have to disclose all of the following from within the past 120 days. 1, if a building had any infestations. 2, if those infestations were eradicated. 3, what floor the infestations were on. And 4, if the unit someone wants to rent had any recent infestations. Finally, 5, if the infestations in that unit were eradicated. I want to add these requirements in because of all the committee prints on this bill across 4 years have emphasized that bed bugs are highly mobile, that they easily move between units, and that a building with bed bugs anywhere is a bed bug building for everyone living there. It sounds like a lot to disclose, but this is based on a New York City disclosure form that landlords there comply with by checking 4 boxes and filling in 2 blanks. And we would all want to know if there are bed bugs next door before moving in. So this amendment extends that courtesy to all tenants. Mr. Chairman, I thank you and your staff for working with me on this amendment. And with that, I move the amendment.
Thank you, Councilmember Nadeau. The amendment is before us. I indicated this morning I have no objection to the amendment. I do want to say this. There was an earlier version of it that spoke of the rental property as opposed to the building. And there are apartment properties that are more than one building. And so this amendment speaks to the building itself. I have no objection to this. If there's no objection, the amendment will be accepted. Is there any objection? Hearing none, the amendment is accepted.
Thank you.
The other amendment is from me. This also was circulated yesterday and linked to the agenda. It makes 3 changes to the committee print as approved on first reading. It changes some language so the housing providers must acknowledge a complaint from a tenant within 5 calendar days rather than 5 business days, and must obtain services from a pest control professional within 10 calendar days rather than 10 business days. It also clarifies that if a unit is reinfested during a monitoring period, because the bill provides that after eradicating bed bugs, there has to be a 12-month monitoring period. And this amendment clarifies that if the unit is reinfested during the monitoring period, and needs additional eradication measures, the housing provider must provide monitoring services for 12 months after the reinfestation. And then the amendment also clarifies that the bill has a requirement that leases must include a language with regard to this legislation. And it's not the intent that this legislation would in any way invalidate leases that currently exist, so that provision applies for lease agreements executed after March 31st, 2023. If there's no objection, this amendment will be accepted. Is there any objection to it? Not hearing any, this amendment is accepted. Are there any more discussion with regard to this bill? Madam Secretary, would you call the roll? The vote is on Bill 24-142 as amended.
Councilmember Trayon White.
Yes.
Member Trayon White votes yes. Councilmember Allen.
Yes.
Member Allen votes yes. Councilmember Bonds.
Yes.
Member Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Member Lewis George votes yes. Councilmember McDuffie.
Yes.
Member McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Member Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. And Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The bill as amended is approved on final reading. On first reading on bills, we have Bill 24-823, 206 Elm Street Northwest Real Property Tax Abatement Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-823 would provide a real property tax abatement during tax year 2023 for property in Northwest Washington, D.C. As mentioned during the committee of the whole earlier, the funds to support this measure were approved by the council as a part of the fiscal year 2023 budget process. And I would ask for my colleagues' support of this measure. So moved.
Is there discussion? Madam Secretary, would you call the roll? The vote is on Bill 24-823.
Sorry. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Member Henderson votes yes. Councilmember Lewis George.
Yes.
Lewis George votes yes. Councilmember McDuffie.
Yes.
Member McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Member Nadeau votes yes. Councilmember Pinto. Councilmember Pinto. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Member Trayon White votes yes. Mr. Chairman, there are 11 yeses and 2 absent.
The bill is approved unanimously. Bill 24-894, Whitman Walker Entities at St. Elizabeth's Tax Rebate Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-894 would support Whitman Walker's expansion to the St. Elizabeth's campus by relocating its Max Robinson Center to St. Elizabeth's. The Whitman Walker entities have provided healthcare services to the District of Columbia's most vulnerable residents for nearly 50 years. The Ward 8 expansion would allow the healthcare provider to increase its treatment capacity from 5,000 patients to 15,000 patients on the east end of the city. Expanded services at the site include primary medical care, behavioral health, substance abuse, dental, and other supportive services. I would ask my colleagues' support for this important measure. So move.
Chairman
Who wishes to be recognized?
Nadeau.
Councilmember Nadeau.
Thank you, Chairman. I'll be brief. I just want to thank Councilmember McDuffie for moving this legislation so quickly this fall. We originally moved this as a BSA subtitle and funded this abatement in this year's LBA, but I agreed with the chairman that tax abatements generally need hearings, and Councilmember McDuffie graciously agreed to move this as fast as possible to make sure that we could keep this home a family and community asset. Now, because of his and his team's hard work, what was a vacant property a few months ago will be a place for the National Society of Black Engineers Jr. to meet and for Howard engineering students to grow and help others. I look forward to voting in favor of this legislation today and urge my colleagues to do the same. Thank you.
Thank you.
Chairman.
Further? Councilmember Trahan White.
Yes, thank you, Chairman. I want to also thank Councilmember Gray. In his absence, I know he will be very proud of this moment. He's been a staunch advocate for health equity, east of Anacostia River, as he called the East End, as well as Councilman McDuffie and the members of the Committee on Business and Economic Development for all your work in bringing this important piece of legislation to fruition. And I also want to thank the Whitman Walker Clinic, who have dedicated their lives and careers to improving healthcare across the district. For nearly 50 years, the Whitman Walker Clinic has provided quality, affordable healthcare services, legal services to youth and families to support DC residents. The Whitman Walker Clinic has consistently been a leader for providing targeted and affirming care to vulnerable groups and was one of the first in the nation to provide extensive services to the LGBTQ and the HIV/AIDS patients decades ago. The current Whitman Walker Clinic, located at Max Robinson Center in Ward 8, has been a consistent source of healthcare and supportive services to district residents east of the Anacostia River, who has historically been denied access to the same healthcare as their counterparts in other wards. This tax rebate will provide Whitman Walker with the financial support to provide critical services to even more of our residents. I'm watching the development go up, and it's been phenomenal. We know that this measure will improve access to healthcare east of the river, and the new location will serve roughly 15,000 residents a year. Whitman Walker has been an invaluable resource to our community, and I'm thrilled to have introduced this measure along with Councilman McGray, and I'm excited about the future of healthcare in Ward 7 and 8, especially on the historic St. Elizabeth property. Again, I want to thank you, Councilmember Gray, in your absence, and know that your work is not in vain. Thank you, Chairman.
Thank you, Councilmember White. Further discussion? The vote will be on Bill 24-894. Madam Secretary, would you call the roll?
Councilmember Bonds?
Yes.
Member Bonds votes yes. Councilmember Che?
Yes.
Member Che votes yes. Councilmember Gray is absent. Councilmember Henderson?
Yes.
Member Henderson votes yes. Councilmember Lewis George?
Yes.
Member Lewis George votes yes. Councilmember McDuffie?
Yes.
Member McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Member Nadeau votes yes. Councilmember Pinto?
Yes.
Member Pinto votes yes. Councilmember Silverman?
Yes.
Councilmember Silverman votes yes. Councilmember Robert White?
Yes.
Member Robert White votes yes. Councilmember Trahan White?
Yes.
Member Trahan White votes yes. Councilmember Allen?
Yes.
Member Allen votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The bill is approved unanimously. Bill 24-935, UDC Leased Property Tax Abatement Amendment Act of 2022. Councilmember McDuffie.
Thank you, Mr. Chairman. Bill 24-935 will provide a tax abatement for the University of the District of Columbia for property it leases at 4225 Connecticut Avenue Northwest for so long as the university continues to lease the property and use it for educational purposes. The council set aside funds in the fiscal year 2023 budget to support this measure, and I would ask for my colleagues' support. So move.
Is there discussion? The vote will be on Bill 24-935. Madam Secretary, will you call the roll?
Councilmember Che?
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson?
Yes.
Member Henderson votes yes. Councilmember Lewis George?
Yes.
Lewis George votes yes. Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto? Councilmember Pinto? Councilmember Silverman?
Camera on. Yes.
Councilmember Silverman votes yes. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen?
Yes.
Councilmember Allen votes yes. Councilmember Bonds?
Yes.
Member Bonds votes yes. Mr. Chairman, there are 11 yeses and 2 absents.
Madam Secretary.
Yes, sir.
I believe Councilmember Pinto's walked into the chamber.
Okay. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The bill is approved unanimously. We will turn now to reading and vote on proposed resolutions. The first is PR 24-776, District of Columbia Housing Finance Agency Board of Directors Brian Scotty Irving Confirmation Resolution of 2022. Before I recognize Councilmember Bonds, I have a sense that while there are some members that have similar views on both of these resolutions, there might be some differences, which is why I'm not suggesting they be moved in block. Just saying that so that, well, I'm not sure why I'm saying that. Councilmember Bonds, with regard to the first resolution.
Thank you, Chairman. The first nominee, Mr. Brian Scotty Irving, was nominated by Mayor Bowser for reappointment as a member of the Housing Finance Agency Board of Directors with experience in home building, real estate, architecture, or planning for a term to end on June 28, 2023. He is the owner and founder of Blue Sky Construction and Development and has served as a member of the agency board of directors for the past 6 years. He has over 16 years of residential and commercial construction and development experience and utilizes his expertise to oversee the successful development of thousands of units of affordable housing across the district. He feels very confident that he's been a good service to the residents of the District of Columbia. I'll go further to just remind that one of the challenges that the Housing Finance Agency Board is competing with is a limited pool of DC residents that are experienced and willing to give their time and knowledge to services on boards and commissions that require specific technical skills. And so that is one of the challenges that we face. And so I move his nomination forward, Chairman.
Thank you, Councilmember Bonds. We have the resolution before us. Is there discussion? Councilmember Silverman.
Yes, thank you, Mr. Chairman. I heard what you said about not moving the nominations in block, but I will speak to both nominees, so maybe I could get a little leeway on time. Mr. Chairman, as I mentioned in the breakfast, I will be voting no on these 2 DC Housing Finance Agency board nominees presented to us today. For those who don't know, the DC Housing Finance Agency is an extremely important affordable housing agency. It's responsible for thousands of units of affordable rental housing and new homeowners every year. And it's absolutely critical to our collective efforts of solving our housing crisis. I want to be clear that I'm voting no, not out of a personal objection to either member, but because this board's members have too often had to recuse themselves because of professional involvement in the project seeking DC HFA financing. I will say that again, because this has often been misrepresented by people who disagree with me. I do not believe the current members of DC HFA board of directors have violated any ethics rules, and they do recuse themselves when one of their development projects is being voted on and approved for financing. To be clear, again, my concern is the frequency in which board members have development projects that receive DC HFA financing. I'll just say, when board members are involved with more than half the deals that they're voting on, I think that is a big concern and a problem. Let me give concrete empirical example. Between January 2021 and August of this year, the board took votes on affordable housing developments 40 times. Of those 40 votes, one or more of the 5 DC HFA board members had to recuse themselves from the vote due to a conflict of interest a total of 26 times. That is 65% of the time. They were voting on projects that involve one of the 5 board members. That is not a system that is free of conflicts of interest. And I'm concerned about the lasting impact of having a system where board members are able to use more than half of the bond authority we have available and have the possible ability to push their competition out of the market. Mr. Chairman, can I get one more minute?
Without objection.
Thank you. So what is the message being sent here? You know, I'm concerned that the lasting impact of having a system where board members are able to use half of our bond authority, you know, does send a message to other developers that the only way they can get a deal done in DC is to give a piece of it to a DC HFA board member. You know, I'm concerned it sends a message that they're not going to be competitive in the district, and they might go to other jurisdictions. And that's something I've actually heard. I think we can have both a conflict-free process and not lose the expertise the HFA board needs. We just have to be willing to do it. And I felt this way for a long time, which is why I previously introduced legislation to prohibit board members from having business with the Housing Finance Agency while they are serving on the board. Other states like Virginia have this kind of legislation in place. But since we don't have this law in place right now, I will be voting on against these 2 nominations. Thank you, Mr. Chairman, for the extra time.
Councilmember Pinto, then Chair.
Thank you, Mr. Chairman. I have a question for Councilmember Bonds, if that's all right. So one of the things that Councilmember Silverman just highlighted was that 60% of the bonds being voted on would affect members of the board. Is that representative of the amount of projects that the board members represent in the city? Like, why is that number so high? Is that more of a matter of other applicants aren't coming to the board? Because that doesn't sound like 60% of those that are approved. It's just 60% that those are being considered. So why is that the case from your understanding?
Thank you, Councilmember Pinto. From my understanding, it is a condition of the projects that come before the board. And if I heard Councilmember Silverman correctly, she said the members, there are 5 members of the board that are falling into this category. but I have not heard anything that would say that nominee Irving or nominee Jackson have some very specific engagement on any of these 26 projects. So it leaves me to go back to my original perspective, and that is that because people serve, and the requirement is to serve if you are a DC resident, we're in a catch-22 in that how do we get others to be willing to give their time to serve in this capacity? And that seems to be one of the biggest difficulties, because it is time consuming. And so these individuals have said, yeah, I'll serve and continue to serve, and they have the expertise. So I think we need to do the necessary research to determine whether or not there was any conflict. We know that in all cases, these individuals who are on the board have reclused themselves, on these projects. They're doing the right thing, the same thing that we have to do here at the council if we have any engagement as it relates to any project that is before this body. So I think, it's an effective way to use statistics, perhaps, but I'm not sure if it really gives us a picture of what is the difficulty.
Right. But unlike our body, 60% of the votes that we take do not result in one of us needing to recuse ourselves. So maybe I could ask Councilmember
that's true.
Silverman, as you analyze this problem, why do you think that is, that 60% of the bonds HFA is reviewing affect the
Can
board
I
members?
just jump in before the answer? As I understood, it was 65% of the measures before the agency
Correct.
have had a recusal by at least one of the members, not 65% by the same member.
That's correct. That's correct, Mr. Chairman. This was a big discussion at the confirmation hearing, Councilmember Pinto. And it gets back to something I think that was asked at the breakfast by another member, which is why can't we have more people who don't have projects before the board serving? And that, I think there's as I mentioned, a concern that, I'm not accusing anyone of a lack of ethics. People recuse themselves, but it just seems like this small group of people seem to have a majority of the projects before the board. And, I'm not sure why that is, but it creates I think a concerning perception among certain developers that you have to, have somebody on the board be a part of your project in order to receive funding.
Right. I guess I'm trying to understand in putting together an application, why that number would be so high. Because it's not that you're saying that 65% of the projects that are submitted, I'm not being clear here.
Well, let me
I'm just
say,
trying
it's
to get
very
the right
rare for
piece
a
of the
member to,
timeline.
it's very rare. I think that, I didn't mean to interrupt you, but I think what you're getting at is, it's very rare for members to vote against somebody else's project who's on the board. And I think that question was, I asked that question and people couldn't really recall when, it doesn't happen with frequency, I'll say. But yes, it is very surprising how many projects come before the board for financing that involve board members. And a solution for us is to just say, while you're serving on the board, you cannot have projects before DCHFA. And then, when you come off the board, you can.
Can I just ask one last piece to Councilmember Bonds?
3 minutes over your time.
I know, but I was trying to allow others to answer. But
Please be mindful of your time when folks are answering. So if there's no objection, one more question.
Thank you. Councilor Bonds, do you have a sense of how often projects are disapproved by the board? And if that's ever happened with the 65% grouping?
I'm not quite sure what the 65% grouping means in from what you're saying, but I do know that not all projects that go before this board are approved. If your thought is how many of those that are not approved do not have the involvement of any member, I would imagine that may be where you're headed, that do not have members that are part of this board, I can get you that information. Because that's a record, a matter of record.
That's a different question. I want to be mindful of my time. So thank you very much.
Thank you, Councilmember Pinto. Further, yes, Councilmember Shea and then Councilmember Henderson.
Thank you very much, Mr. Chairman. As I said at the breakfast, this is very concerning, both for what may be happening and what may appear to be happening. And while I suspect that these nominees will be approved, I'm going to vote no also as a signal that this council, without me on it, but nevertheless, that this council would like the pool of people who are looked at to serve in these capacities is broader and would limit the potential for conflict of interest. So I think it's at least a signaling vote. Thank you.
Councilmember Henderson.
Thank you, Mr. Chairman. I have a question for Councilmember Bonds. I understand that Mr. Irving and Mr. Jackson are reappointments. How many other terms have they served prior to this reappointment?
Yes, Mr. Irving has served since 2015. And Mr. Jackson has served since 2016.
Okay, and what's the length of terms?
It can be 1 year or 2 years. I think they were appointed to 2-year terms. The term that they are currently being appointed to is 1 year.
Okay, thank you. I raised this in the breakfast as a question of concern. And again, I'm not on the housing committee, so I didn't attend that particular nomination hearing. So I'm not ascribing anything to Mr. Irving, or Mr. Jackson. But I feel like these are conflict of interest that we should be questioning. And while I understand, Councilmember Bonds, you saying it is hard to find the right combination of person who's also a DC resident, I feel like we've had debates on this body before around us having lots of qualified DC residents who have the experience and background, but we haven't necessarily done the outreach to get those folks to either apply to MOTA to serve on boards and commissions or otherwise. But I don't know how we change direction on some of these things if we continue to just vote yes on everyone who comes before us. I have concerns about some nominations that were sent to us on another body that doesn't even involve, that's not under the housing committee, that's actually under government operations. And because it seems like the same people not necessarily addressing the issues at hand. So I just wanted to make that note on the record. Thank you.
Thank you, Councilmember. Councilmember Robert White.
Thank you, Mr. Chairman. I think we're hearing some concern that's valid and that we should take very seriously. As I mentioned at the committee of the whole meeting, the code has a broad qualifications for members of the board. It's a 5-member board. They have to be DC residents, 2 with experience in mortgage lending, finance, and someone with experience, 2 people with experience in home building, real estate, architecture, or planning, and 1 representative of the community or consumer interest. So these are broad categories. Seems like a lot of people would qualify. If it is the case that not a lot of people want to do it, then we have to ask ourselves why.
That's true.
And that why would be very important. And the why may have to do with what we're debating here, a perception that you have to be plugged in. And so we do have to start to change things. I haven't heard any specific concern about these specific nominees. But I think it is clear that there's a discomfort with the lack of the pool, whether it's by lack of effort or something else going on. So I'm going to vote present on these because I don't have a specific concern with these nominees, but I do have a concern that we are not looking broadly enough, or that people are not interested in joining this board for some reason that we need to understand. So my hope is that we will start to look at Councilmember Silverman's bill to understand if we need to change the qualifications or however we get to that why. Why are we here with people who have a vested interest in the Housing Finance Agency being on the board? We have to get to the bottom of that. So I think we have an opportunity here, and hopefully we can work in the Housing Committee to dig into qualifications so that we don't end up here. Because my sense is that folks are going to start voting no and increasing numbers on these types of nominations. Thank you, Mr. Chairman.
Thank you, Councilmember White. Councilmember Trahan White.
Yes, my question is to Councilmember Bonds. I see listed on their website, they have 4 active members with a vacancy in the chairman position. Do we know how many new people have been recommended to the board in these 2-year cycles?
I do not have that information, but I certainly can get that. I
So,
can get that information.
I guess since you've been the chair of the Housing Committee, have you been seeing any new recommendations of people that's been brought to the council? And have we, because I know it was another chairman that was there, I guess a few years ago, actually.
Mhm.
And so I'm anticipating they're going to recommend someone else. But do we know that there are other people that's come to us that we have looked through outside of the normal people that's been there for this period of time?
I think they all are the normal people that I know of, but I have seen 3 other nominees, yes.
And those nominees came before the council?
No, yes, they've come before the council, yes. Because they were nominated and the resolutions moved forward to the council. Ms. Howard is one of the individuals in this group of individuals.
Okay, her tenure is not up at the moment. I don't see her on.
Yes, she had a 1-year term, and so she's being renominated.
We just approved her
Okay,
half an hour ago.
so she
And
has
Miss-
1 year and others have 2 years?
Mr. Irving, he came before us in 2015. You said during my tenure.
Yes,
correct?
ma'am.
Okay. And Mr. Jackson in 2016. So all 3 are those individuals who came before the council during my tenure, if that's your question.
And I think I remember Ms. Howard was on the consent agenda and these 2 were pulled off. Is that accurate?
For today, yes, it is. Mhm.
All right, thank you.
Second round, Councilmember Pinto.
Thank you, Mr. Chairman. Oh, are you in? I think there is an understandable and necessary appetite to be more exacting with our nominations, especially when it comes to housing and these projects that are being reviewed, and making sure that there are clear rules in place around conflict of interest and reporting. And I think that we should continue working on this. As I hear some of our colleagues speak, I'm not hearing specific concerns with these nominees, but more just a broader concern to make sure that we are either looking at a broader pool of applications or having clearer rules. And so I'm going to be supporting these nominees today as we look for other ways to try to achieve what I think is our shared desire here of making sure that there are fair opportunities for all and no kind of pay to play activities going on. Thank you.
Okay.
Thank you,
Mr.
Councilmember.
Mr. Chairman, if I could just add, staff just gave me the information that indicates that as when we presented the resolutions, it was made clear that these were nominations from May of 2021. So these are technically retroactive nominations, which would be for the 2 years. And they will have approximately a few months because they expire in June 28th of 2023.
Thank you for that clarification. I'm also going to be voting in support. I've heard nothing either here in this debate or outside of this debate that has questioned the service of Brian Scotty Irving or Stanley Jackson. And I would go further, and as I reflect, I have not heard that the Housing Finance Agency Board has been making a lot of mistakes or mired in scandal. So I think it might be salutary to the mayor that she should be looking at some, how do I want to put this, a fresh pool, but I'm comfortable with voting for these folks today, recognizing that they have served and served without controversy, and that the Housing Finance Agency has done pretty well in the sphere of our housing agencies. So again, I'll be in support. If there's nothing further on this, we have PR 24-776 before us. Madam Secretary, would you call the roll?
Councilmember Gray is absent. Councilmember Henderson.
Mr. Chairman, can we get a roll call, please?
The secretary is calling the roll right now.
I'm
Councilmember.
sorry, Mr. Chairman. As you know, I'm rarely remote, but I was looking for the button to speak up.
Madam Secretary, please continue.
Councilmember Henderson.
Present.
Councilmember Henderson will be recorded as present. Councilmember Louis George.
No.
Councilmember Louis George votes no. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
No.
Councilmember Nadeau votes no. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
No.
Councilmember Silverman votes no. Councilmember Robert White.
Present.
Councilmember Robert White will be recorded as present. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
No.
Councilmember Che votes no. Mr. Chairman, there are 6 yeses, 4 nos, 2 present, and 1 absent.
The resolution is approved. We have PR 24-778, District of Columbia Housing Finance Agency Board of Directors, Stanley Jackson, confirmation resolution of 2022. Councilmember Bonds.
Thank you, Chairman. Mr. Stanley Jackson was nominated for reappointment as a member of the Housing Finance Agency Board of Directors, representing community or consumer interests for a term to end on June 28th, 2023. And he is first appointed to the Housing Board of Directors, continuously serving since 2016. He is president and CEO of the Anacostia Economic Development Corporation. Mr. Jackson has over 3 decades of housing and economic development experience, service in key private, public, and nonprofit leadership roles. During his tenure with the district, he directed the district's participation in development of over 6,700 units of newly constructed and rehabilitated affordable housing for seniors, special needs, and a very low to moderate income district residents. He also served in our government as the Deputy Mayor for Economic Development. I move his nomination forward.
We have the resolution before us. Is there discussion?
Mr.
I-
Chairman, I'll request a roll call early.
Okay. If there's no discussion, we'll have a roll call. Madam Secretary, would you call the roll?
Councilmember Henderson.
Present.
Councilmember Henderson will be recorded as present. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Member McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Silverman.
No.
Councilmember Silverman votes no. Councilmember Robert White.
Present.
Councilmember Robert White will be recorded as present. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Present.
Councilmember Che will be recorded as present, and Councilmember Gray is absent. Mr. Chairman, there are 8 yeses, 1 no, 3 presents, and 1 absent.
The resolution is approved. The next measure on the agenda is, and we're now under emergency legislation, District Government Family Bereavement Leave, Second Emergency Declaration Resolution of 2022. Councilmember Silverman.
Yes, thank you, Mr. Chairman. We passed emergency and temporary legislation in early 2021 and extended it in early 2022 when a loss experienced by one of our DC Public Schools teachers made it clear that we needed to improve our workplace leave policies. With the current temporary set to expire on November 19th, I am moving this emergency legislation today while the permanent bill is finalized. Dealing with the loss of a loved one is one of the most difficult circumstances we face as human beings. Determining how much paid time off we give our DC government workers to grieve and process that loss is one of the most difficult and challenging decisions we face as policymakers. We all want to provide compassionate, fair, paid bereavement benefits for our workers. Before the loss suffered by our DC Public Schools teacher and the actions to update our law on an emergency basis, DC government provided only 3 days of bereavement leave under any circumstances. There was also no paid medical leave other than 6 days. That's why the earlier bills in today's legislation does expand that to provide an additional 10 days to parents who lose their minor child or for women who experience a stillbirth. There is also a pending permanent version of this bill, which was re-referred to the Committee on Health this past summer. I understand the Health Committee will mark it up and move it to the full council by the end of this year. I want to thank Councilmember Gray in his absence for his work here, and I look forward to voting for the permanent version soon. Thank you, Mr. Chairman. I encourage my colleagues to support the declaration.
Thank you, Councilmember Silverman. We have the declaration before us. Is there discussion? Madam Secretary, would you call the roll? The vote is on PR 24-1026.
Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Member Nadeau votes yes. Councilmember Pinto.
Yes.
Member Pinto votes yes. Councilmember Silverman.
Yes.
Member Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Yes.
Councilmember Che votes yes. Councilmember Gray is absent, and Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The declaration is approved unanimously. The underlying bill, Bill 24-1075, Councilmember Silverman,
I move the underlying emergency, Mr. Chairman.
we have the bill before us. Is there discussion? Since the declaration was approved unanimously, we'll do a voice vote on Bill 24-1075. All those in favor say aye.
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 Are there any no votes? Madam Secretary, I don't see or hear any no votes. Do you agree?
Couldn't get off of mute. Agreed, Mr. Chairman.
The bill is approved unanimously. The next measure is CREAC Assistance Fund Emergency Declaration Resolution of 2022, PR 24-1030. Councilmember Che.
Well, thank you, Mr. Thank you, Mr. Chairman. Today, on behalf of the mayor, I'm moving the CREAC Assistance Fund Emergency Amendment Act and Declaration of 2022. As members know, during the public health emergency, residents across the district faced unprecedented financial hardships, with many struggling to pay rent and utility bills. But for this council's actions, establishing moratoria on both evictions and utility shutoffs, as well as requiring landlords and utilities to stand up payment plans, many residents may have lost their homes or have had their utility service shut off during the pandemic. I do want to note, however, that DC Water did proactively act to halt shutoffs for customer non-payment, and I applaud them again for that decision. Unfortunately, although the public health emergency has come to an end, many residents are still reeling from the financial effects of the public health emergency and the COVID-19 pandemic. A number still struggle to make ends meet, including paying rent and utility bills. It's critical that we ensure that available funds are able to be put toward providing relief for these residents, especially those at imminent risk of having their service being shut off. This emergency legislation would amend the eligible uses of amounts in the Clean Rivers Impervious Area Charge, CREAC, Assistance Fund to include providing relief to low-income residents. Residents eligible for relief would include those at 100% AMI or less, and who, due to amounts owed to DC Water, are at risk of their service being shut off during fiscal year 23. I'll note the mayor used amounts in the CREAC fund for low-income relief during the pandemic, as well as what we're offering today, ensuring that those dollars went as far as possible. Specifically, the legislation would authorize the mayor to redirect amounts in the fund, but caps those amounts to dollars that remained in the fund at the end of the fiscal year on September 30th, 2022. That exact amount is uncertain, but based upon my conversations with the agency and our budget office, I anticipate that this will be between $500,000 and $1.4 million. Those are amounts remaining after all nonprofits and residential customers that applied for and were found eligible for CREAC relief have received funds under the program. So this should not prevent any household or nonprofit from accessing relief under the CREAC program. And I anticipate those customers struggling the most to pay their CREAC fee are also facing the most difficulty paying their water bills more generally. So this emergency will serve to meaningfully direct those dollars to those who will most benefit from financial relief. Separately, the emergency also includes 2 technical fixes to emergency legislation we adopted in September on the battery and electronic stewardship programs run by DOE. That legislation inadvertently, just one more line, couple of lines, inadvertently trimmed off the 2022 deadline for the producers to submit proposed battery stewardship plans to DOE. This language now reinserts that deadline. The amendments here also clarify that manufacturers are required to accept electronic equipment for recycling and reuse when the same type of equipment is purchased. And I would move the emergency declaration.
Thank you, Councilmember. We have the declaration before us. Is there discussion? The vote will be on PR 24-1030. Madam Secretary, would you call the roll?
Councilmember McDuffie?
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson?
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau?
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto?
Yes.
Councilmember Pinto votes yes. Councilmember Silverman?
Yes.
Councilmember Silverman votes yes. Councilmember Robert White?
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White?
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
yes,
Councilmember Bonds votes yes. Councilmember Che.
yes,
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes, and Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 24-1083. Councilmember Che,
so move,
is there discussion? Since the declaration was approved unanimously, we'll do this by voice vote. The vote is on Bill 24-1083. All those in favor say aye.
Aye.
Opposed? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. The next measure is coronavirus immunization of school students, emergency declaration resolution of 2022. ER 24-1022. Councilmember Henderson.
Thank you, Mr. Chairman. This measure was introduced with your support after the Committee of the Whole held a public roundtable on October 11th of this year on the enforcement of the district's no shots, no schools policy for school year 22-23. At that roundtable, we learned what we had suspected was true, that after years, decades of not enforcing our vaccination mandates for students, and after 2 years of the pandemic in which vaccine misinformation spread like a virus, district education leaders have encountered difficulties in convincing families to make health choices for their students that conform with the best public health practices. At that hearing, we also learned of some of the difficulty in enforcing the vaccine mandates. For example, the city uses 3 different databases to track vaccine compliance. And at the time of the hearing, the databases were not completely aligned. We also learned that parents were more willing to be compliant on the routine pediatric vaccinations, such as measles, mumps, polio, in comparison to the COVID-19 vaccinations, and discussed how the COVID-19 landscape has changed. Almost a year ago, when the council voted to pass the legislation, I introduced coronavirus immunization of school students and early childhood workers Amendment Act of 2021. The district was in the midst of an unprecedented surge of COVID-19 cases stemming from the new Omicron variant. I didn't introduce that bill with the knowledge of the Omicron variant, but the rising cases did lend urgency to the council accomplishing this goal prior to the winter school term. Now, science and technology are more on our side than in December of 2021. Most of the vaccines have full FDA authorization. Only those for children 5 and under are still operating under emergency use. While we are still dealing with the Omicron variant, the CDC has approved bivalent boosters and just 2 weeks ago signed off on an updated first vaccine for children that will be more effective at preventing illness caused by the BA-4 and the BA-5 Omicron variants, against which the original vaccines had comparatively limited efficacy. A year ago, we approved a measure that seemed to be our best chance at containing this virus. We have more tools at our disposal now. Not only are vaccines that prevent hospitalization and death, but antivirals for the most vulnerable. As the virus mitigation landscape changes, I believe the district's approach must evolve as well. With these considerations in mind, I ask my colleagues to support this measure that delays the enforcement of the COVID-19 vaccine mandate to school year 23-24. I think it's in the best interest of our students to delay enforcement of this provision. Students can still get their COVID-19 vaccinations in the meantime, and we would certainly encourage them to do so, but they will not be excluded from school over that. Mr. Chairman, can I just have a little extra time? I see the clock ticking down.
Without objection.
We must make policy as realist. And the reality of the situation is that the information vacuum created by the pandemic also created opportunities for falsehoods to flourish. We have to meet people where they are, and many people still aren't ready to accept this particular treatment. We also don't want to exclude students from the classroom after working so hard with our education leaders to get them back into school in person. This extension will ensure that students have time to receive the most up-to-date and effective disease prevention treatments, allow parents and students the additional time they need to get better educated about the COVID-19 vaccine efficacy and merits, and grant the district a bit more time to reconcile its databases upon which it will make student exclusion determinations. With that, I move the declaration.
Thank you, Councilmember Henderson. Discussion? Councilmember Lewis George, then Pinto, then Tran White.
Thank you, Chairman. I think what we saw when we were all at the hearing together, and one of the things we saw with the routine pediatric immunizations was that thousands of students got into compliance at the very end. Literally, the numbers changed over the weekend because, and I think they got into compliance because at the very end, they saw that the district wasn't going to change their minds. And so I'm worried that we lose credibility when we change our minds like this. And so I'm wondering, what commitments do we have from the executive to continue promoting COVID vaccines and working with families to get vaccinated to protect themselves and others? I think I would love to hear just some of those commitments, because as a city with one of the highest rates of childhood respiratory issues right now, I don't want us sort of delaying implementation to signal in any way to the mayor or the public that we are taking our foot off the gas on getting our families to receive their primary dosage rounds. So if you could speak to that.
Councilmember Henderson.
I don't have any specific commitments on that. I will say the district set up COVID centers to have a more permanent presence in every ward. The COVID centers are open most cases 6 days a week until 8 p.m. in some cases. They also offer masks, flu shots, tests that individuals would need. And there's been no indication from the executive that they plan to roll any of that back at this particular state. And there has been no indication from DC Health or from OSSI that they plan to roll back their communications to families as well in terms of the importance and efficacy of all immunizations.
Okay, I appreciate that. And although I'm reluctant, we need students in school. I think that's, at the end of the day, we need our students to be in school and learning. So I'm hopeful that we will continue to keep our foot on the gas no matter what as the council to make sure everything is happening that needs to make sure our families are getting up to date. Thank you.
Thank you, Councilmember. Councilmember Pinto.
Thank you, Mr. Chairman. And I want to thank you and Councilmember Henderson for working on this issue and trying to be responsive to the ever evolving nature of COVID. But I am not supporting this measure today. I don't think we should be extending the date of compliance for students to receive COVID-19 vaccines until next school year, as we have already extended the date of compliance. We know that COVID-19 vaccines are safe and the most effective way to prevent serious illness, hospitalization, and death. I want to address briefly 3 arguments that have been made to delay the enforcement date. First, that we are in a different place with COVID now than we were when we passed this bill last spring during the Omicron surge. While it's true that case rates are currently lower than they were last spring, this is in large part due to people getting vaccinated. We're also entering winter, which is when we experienced a spike last year, and health experts, including the White House COVID-19 response coordinator, Ashish Jha, are expecting a spike in cases in the coming months. Case rates are spiking again in Europe, and they tend to precede us by about 4 to 6 weeks. The second argument I've heard is that children are at lower risk for severe COVID, but the reality is that children are still contracting COVID-19 and spreading it to those around them. A study by Harvard Medical School found that children have as much or more coronavirus in their upper respiratory tracts as infected adults, and that a child with mild or no symptoms may have just as many viral particles as a child with more severe symptoms. We need to be doing everything we can to keep our kids and school staff and teachers healthy and safe, especially as we continue to face teacher and substitute teacher shortages in our city. And finally, I want to address the argument that we shouldn't be requiring the COVID-19 vaccine when the bivalent vaccine is on the way. I don't believe this is in line with the CDC guidelines. The CDC recommends that children who have not received a single dose of COVID-19 of the vaccine should get vaccinated as soon as they can. And for those who are already vaccinated, they should get the bivalent booster for additional protection. The current vaccine is still effective, and we should not use the bivalent booster as a reason not to enforce COVID-19 vaccine mandate this winter. Lastly, I want to note my deep concern that by extending the deadline once again, we are jeopardizing our ability to enforce other vaccine mandates down the line, and that we are unintentionally feeding into vaccine misinformation that they're ineffective. So I won't be supporting this measure today for those reasons. Thank you.
Thank you, Councilmember Pinto. Councilmember Trayon White.
Thank you, Chairman. Happy to see that we are dialing back on the requirements that school-age kids have to be vaccinated in order to get in-school education. The conversation evolved from mandatory vaccines and hope to stop a person from receiving or passing the virus to mandatory vaccines to keep people from dying. To this virus, I'm sorry. The conversation have evolved from mandatory vaccines to hope to stop a person from receiving and passing the virus to mandatory vaccinations to keep people from dying, to the virus having a new strain, to a booster, to another booster, and to a new booster just 2 weeks ago. This was a new phenomenon for us all, and we all had to figure it out while being smack dab in a crisis. The government, I believe, overstepped its boundaries, circumventing parental approval to vaccinate children. I think that need to be dialed back as well. The CDC has not recommended we require students to be vaccinated to go to school. And so although we're pushing it to next year, I think this is the beginning of a start of evolving as we grow as a council and learn more of the effects and the evolution of this virus. Thank you.
Thank you, Councilmember. Further discussion? Councilmember Henderson, do you mind if I speak for a moment?
As Mr. Chairman, please note that Councilmember Silverman wishes to be recognized as well.
All right, Councilmember Silverman, and then me, and then Councilmember Henderson.
Thank you, Mr. Chairman. In listening to the conversation right now and at the breakfast meeting, this is a difficult vote because we all agree on this dais that the COVID vaccine is safe and effective. We want all of our residents who can be vaccinated and boosted to do so for their own health, for the health and welfare of their families, and for our health as a city, as I think Councilmember Pinto mentioned. But the reality is there are still many residents who are not vaccinated, and many of those residents are school-age children. In the breakfast meeting, a number was cited that there are 23,000 school-age children not vaccinated. If I'm not mistaken, that would be 1 out of 4 of our public school students about. And that's what makes this difficult. I don't want to put a policy in place that's going to keep those kids from school right now. I think it was said before by another colleague, but we need to move the needle on getting these kids vaccinated, whether it be continuing to persuade parents the vaccine is safe, or I think this was suggested in the breakfast meeting, again, setting up mobile clinics at schools to make the vaccine as easily accessible as possible, whatever it takes. I'm also a reluctant yes today because I want kids in school, but we also need to move the needle on increasing the vaccination rate during this delayed implementation. Thank you. I know Councilmember Henderson and Mr. Chairman, you put a lot of thought into this, so I thank you both.
Thank you, Councilmember Silverman. Councilmember Allen.
Thanks, Mr. Chairman. I'll kind of echo a couple of sentiments here that I've heard, which is this is a really tough vote. As I have weighed this and talked with lots of parents around what they think and their concerns and their continued fears around the spread of COVID. This vote seems to really try to come down to we're being asked to make a choice between two harms. And trying to be, to some degree, realistically weighing which harm is an acceptable harm, which is an incredibly difficult thing for us to have to think through. And I hope it's stated strongly and unequivocally that we want children vaccinated. Vaccines work, they are safe, they are effective, and we need to have every child be vaccinated. And then we're also faced with the reality that tens of thousands of students would not be able to be in school and in class. And seeing the reality of the stark and steep impact that has on those students in school, and beyond just the academics, everything else in that student's life, the resources, the connections, the supports. This is a tough one, but I am going to support this today. Not because I don't believe that every single kid needs to be vaccinated, but because I believe the harm of having that many kids pulled out of our school system would be incredibly detrimental. And it is just a very difficult vote to cast to try to figure out between two different harms, which one we go with today. So I hope everyone understands the wrestling that many of us are feeling around this, but the recognition of it moving forward. Thank you, Mr. Chair.
Thank you, Councilmember. Councilmember Che.
Thank you, Mr. Chairman. And Councilmember Allen has it just right. We're being asked to weigh two things, and it's very difficult. Although I do want to say that perhaps one of the reasons why many thousands of children have not been vaccinated is because we have signaled that we are not going to take seriously requiring the vaccinations. We haven't tried efforts like having, as I said this morning, pop-up vaccination clinics right around schools, so that students who are otherwise not vaccinated could get vaccinated right then and there and go walk right through the schoolhouse door. We are sending a very, very bad signal here. And we have created this difficult choice, these two binary outcomes. And it's hard to determine which is worse. This is extremely difficult and hard to measure. You like to think that, well, at the end of the day, if you think hard enough about it, you'll know where you're going to come out. And it's still, for me, indeterminate. So I may just vote present because I can't pick my poison here. Thank you, Mr. Chairman.
Thank you, Councilmember Che. Councilmember Bond.
Yes, thank you, Chairman. I will be supporting today's legislation with the hope that we will put in place a plan such as that proposed by Councilmember Shea, where why we are going to delay it, we also can make sure that immunization can come to the schools where the kids are. Thank you, Chairman.
Thank you, Councilmember Bonds. I'm going to say a couple of things. First of all, it's not correct to say that we haven't tried. The committee of the whole had a hearing on October 11th. There was testimony from a number of public witnesses and then representatives from the Department of Health, DC Public Schools, OSSI, the Charter School Board, and the Deputy Mayor for Education. And what was said at that hearing is that the executive agencies have actually tried very hard and done a lot with regard to expanding access to vaccines. I mean, incredibly. They had personnel stationed in many of the schools. They had mobile clinics. They had multiple sites where people could go. The cost of getting vaccination was eliminated. They tried in so many different ways. There wasn't a question that came out of the hearing whether the executive was trying. But in my view, this legislation, and I support this legislation, I'd better since I'm co-moving it with Councilmember Henderson, is not because, for me, it's not because the take-up rate with COVID vaccine is lower than with the other vaccines. It's because I think it is time to question whether we should have a mandate in place for this vaccine. Now, this bill doesn't eliminate the mandate. It simply puts it off for a year, which gives us time to look at this more. I want to say this. This council has been very good about adhering to the science for what, 3 years now, 2.5 years now. Over and over again, we have seen the country rife with controversy over whether to wear masks and whether to shut down and whether to reopen. And all along, we've been following the science. And a year ago, the science was pretty clear. Not enough people were getting vaccinated. People should get vaccinated. The Omicron or the Delta, I can't remember which variant, was on the verge of surging, and we thought it was going to be more lethal. Not only were we focused on mandating vaccines, but we were very concerned that we were just going to see this pandemic get worse and continue. That's where we were a year ago. And Councilmember Henderson came forward with legislation to impose a mandate. This looked like something that was going to be picked up around the country, right around the time California, the state of California, adopted a mandate statewide. We seem to be very much in step and following the science. A year later, where is the science? I just now checked the CDC website. It does not say schools should mandate the COVID vaccine. It does not say that. The science does not say the mandate is what they recommend. In addition, what we're seeing is that some of the jurisdictions that had it, Councilmember Henderson, I believe you said this morning, California has postponed the mandate. What we're seeing is that the pandemic is evolving into more of an endemic. And so it's a different situation. But this legislation doesn't say kill the mandate. And as again, I repeat, this is not in my view, oh, the take-up rate is low and therefore, no, it's what does the science say? And the science, if anything, suggests that maybe we should think about this more. And I've said that we will have a hearing in the spring to look at this. And so I think it's completely appropriate to move forward with this legislation that with regard to the COVID vaccine says, let's wait till next school year and sort this out a bit more and understand the science and understand where the COVID virus is going. So that's why I'm supporting this. For Councilmember Henderson, you were next.
Thank you, Mr. Chairman. I just wanted to address something that both Councilmember Bonds and Councilmember Che brought up. In terms of the number of clinics and appointments that were made available. But I did have a conversation both with Dr. Farley at the hearing and then Dr. Lewis at the head of, or the interim or acting head of DC Health. Because I said something similar, Councilmember Che, of like, if we know that X number of students are all missing the same vaccine, why can't we just bring the vaccine to them, have their parents sign a permission slip and just do it? And unfortunately, health insurance gets involved outside of COVID when you're talking about other immunizations. And then they also brought up some other logistical challenges with that. But I know it's hard for us to remember back to a year ago, but we gave out AirPods, we gave out gift cards, we gave out college scholarships. I think we've done a lot on our front. We've had mobile clinics and have really, I think, stepped up our work with community-based organizations to increase public health awareness around the importance and efficacy of vaccines. Prior to this meeting, I circulated amongst the colleagues the latest reporting from the Back to School Safely Reporting Emergency Act, I think that Councilmember Lewis George introduced, where we are required, or where DC Health and OSSI are required to send us biweekly updates on the numbers of compliance. And I just want to say where we are as of October 24th for the record. And I'll just give you a couple of LEA examples as opposed to bringing up specific schools. So for routine pediatric immunizations, the non-compliance rate for DCPS right now is 23%. Now, I know that seems high, but I think people need to also keep in mind that we haven't started the enforcement for middle and high school grades yet. In contrast, the non-compliant rate for DCPS for the COVID vaccine is 44%. Another LEA that has multiple campuses, Friendship Public Charter School, the non-compliant rate for routine pediatric vaccines is 22%, whereas the non-compliance rate for COVID is 60%. So we have students who and their families who are choosing to get vaccinated in terms of the routine pediatric vaccines, but are making a different choice in terms of COVID. And I think this data kind of bears that out a little bit more. Thank you, Mr. Chairman.
Thank
Can
you,
I ask a follow-up question about this?
Councilmember Che.
Councilmember Henderson, you're saying things were done, the chairman said things were done. But you also started to identify maybe what the obstacles are. If it's insurance or money, we can take care of that. If it's ready access or more frequent access to COVID vaccines, we can take care of that. But I fear that it's simple unwillingness based upon stuff that goes out there in the ether about whether this is safe and all the rest of that. The anti-vaxxers are having, they're having their day on this. And I think that we add to that by saying, I know you're saying, the chairman saying that we're just postponing it, but we're on our way to saying we're not going to require it. Well, the same is true of other vaccinations. People may have qualms, but do they have a right to subject other people to illness, whether it be teachers or staff or other children? It seems to me that if COVID is still a serious problem, maybe we don't think it is, but if it is, then it seems to me we ought to take steps just like we do with other serious transmissible disease and require vaccination. And if there are these obstacles, we can overcome them. I'm not sure, which is why I have this hesitancy. I'm just not sure that we've taken all the steps we can, like, for example, paying for the vaccine or what have you, to get people to comply. And we're encouraging them now not to comply. Thank you.
I'm going to jump in here and read from the Department of Health's testimony. The first strategy was to ensure immunization access to all families across the district. There are now more than 50 standing clinic locations in the District of Columbia where families can access routine pediatric immunizations for their children. We worked with our partners to hold 37 mobile clinics, mostly at schools, and 25 vaccine exchange clinics. We also opened the doors of 7 school-based health clinics to all children through September. Starting in August, DC Health worked with Children's National, Unity, and Mary Center to begin holding weekly special vaccination-only clinics for families that were unable to schedule routine well child exams in time for the start of the school year. Beginning last week, Children's National opened high-volume vaccination opportunities at 5 clinics across the district. These clinics are open from Monday through Friday, as well as weekend and evening hours, to accommodate families who may not be free during traditional hours. This week, we announced an additional partnership with Safeway to offer high-volume vaccination-only clinics during the week that pre-K through grade 5 students are scheduled to be excluded from school due to non-compliance with immunization requirements. And it goes on for another page or two if you want me to read it, but the point is that they actually have done a lot to increase access. Councilmember Pinto?
Thank you, Mr. Chairman. And I would agree that the city has done a lot to increase access, and some of the examples that Councilmember Henderson cited around scholarships and iPads and gift certificates, I think played a big role in that. And I also think vaccine requirements played a big role in that. And as Councilmember Lewis George mentioned, when we looked at across other categories, the weekend or week before enforcement was set to start, then numbers really went up. And so we know this can be effective. We still have a couple of months before compliance. I want to just lastly read from the CDC website, since we're citing different recommendations. This is in response to the question, should parents and caregivers wait for updated or additional vaccinations, even if a child's risk of infection is low? And the CDC says, parents and caregivers should get their child vaccinated as soon as vaccines are available to them. Getting vaccinated provides the best protection against serious illness if a child gets infected with the virus that causes COVID-19. Since there is no way to tell in advance how children who are not moderately or severely immunocompromised, or those who may be, a child can be immunocompromised and still healthy, will be affected by COVID-19, and it's important to get them vaccinated as soon as possible to protect them from severe illness. So Just wanted to add that to this discussion because it seems like a lot of people are saying we still think the COVID-19 vaccines are safe. But I would just say we're only on November 1st. We have a little bit of time, and let's try to use this tool to get as many folks vaccinated as possible, especially our kids, to keep them safe and our teachers safe.
If there's no further discussion, we'll have a roll call vote on the declaration. The roll call is on PR 24-1022. Madam Secretary?
Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto.
No.
Councilmember Pinto votes no. Councilmember Silverman.
Yes.
Councilmember Silverman votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Che.
Present.
Councilmember Che will be recorded as present. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes, and Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Mr. Chairman, there are 10 yeses, 1 no, 1 present, and 1 absent.
The declaration is approved. On the underlying bill, Bill 24-1069, Councilmember Henderson.
So moved, Mr. Chairman, but at this time, I would also like to move an amendment in the nature of a substitute, which had been circulated.
Okay.
Can I
proceed.
speak to explain? Upon reviewing the bill, the General Counsel recommended some changes to the emergency and temporary bills, some of which were technical that corrected some drafting errors. But it doesn't change the underlying impact. Thank you.
We have the amendment nature of a substitute before us. If there's no objection, we will treat it as accepted without objection. Is there any objection? Hearing none, it's accepted. We have the bill as amended. Is there discussion? Since the declaration was approved, we'll do a voice vote on this. If anyone wants to be recorded as no or present, please speak up after the vote. On the bill, Bill 24-1069 as amended, all those in favor say aye. Aye.
Aye.
Are there any opposed?
Present.
Councilmember Che will be marked present. No, this is on the bill as amended.
This is on the bill.
No.
The bill is approved. Councilmember Pinto will be recorded as no, and Councilmember Che will be recorded as present. The next measure is Criminal Justice Involvement Reduction Emergency Declaration Resolution of 2022, PR 24-1027, Councilmember Robert White.
Thank you, Mr. Chairman. This emergency and temporary legislation would continue in law requirements that the Criminal Justice Coordinating Council, or CJCC, submit reports to the mayor and the council to determine what factors, programs, or interventions effectively prevent district youth from entering the juvenile and criminal justice systems, and to analyze the types of school-based incidents that lead to law enforcement referrals or arrests. The prior Criminal Justice Involvement Reduction Temporary Amendment Act of 2021, to which this renewed legislation conforms, will expire on November 13th of this year. While the CJCC provided the first 2 of 3 critical reports, it is important that the provisions of the existing emergency and temporary legislation continue in effect without interruption until a permanent version of the legislation becomes law. The first study identifies the protective factors, programs, and interventions that are most successful at keeping young people out of the juvenile and criminal justice systems. The second study analyzes protective factors that reduce the risk of district youth entering the juvenile and criminal justice systems and includes recommendations informed by best practices in other jurisdictions on which factors, programs, or interventions effectively prevent district youth from entering the juvenile and criminal justice systems, such as access to stable housing, nutrition assistance, healthcare, violence intervention, early intervention, and educational, recreational, and youth programming. The third and final report is due by October 1st, 2024. In the final report, the CJCC will analyze the types of school-based incidents that lead to law enforcement referrals or arrests, and whether factors such as economic resources, race, individualized education program eligibility, mental health conditions, school location, and school resource officer assignments statistically affect the likelihood of enforcement referrals or arrests. Move the criminal justice involvement reduction emergency declaration resolution of 2022.
Thank you, Councilmember White. We have the declaration before us. Is there discussion? The vote will be on PR 24-1027. Madam Secretary, would you call the roll?
Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto,
Yes.
Member Pinto votes yes. Councilmember Silverman,
Yes.
Councilmember Silverman votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White, Councilmember Trayon White, Councilmember Allen,
Yes.
Member Allen votes yes. Councilmember Bonds,
Yes.
Member Bonds votes yes. Councilmember Che,
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Member Henderson votes yes. Councilmember Lewis George,
Yes.
Member Lewis George votes yes. Councilmember McDuffie,
Yes.
Member McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Mr. Chairman, there are 11 yeses and 2 absents.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 24-1077. Councilmember White,
So moved.
discussion? Since the declaration was approved unanimously, we'll do this by voice vote. The vote is on Bill 24-1077. All those in favor say aye. Aye.
Aye.
Are there any no votes? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. The next measure is Advisory Neighborhood Commission's Pandemic Provisions Extension Second Emergency Declaration Resolution of 2022, PR 24-1028. Councilmember White.
Thank you, Mr. Chairman. This legislation will continue 2 provisions from prior emergency and temporary acts to ensure our ANCs have the flexibility to serve their constituents effectively and efficiently. During the public health emergency, a number of ANCs around the city found that attendance and public engagement at remote meetings was much higher than they had seen at in-person meetings prior to COVID. They also found remote meetings to be more efficient and easier for commissioners to balance their commission responsibilities with their jobs, personal lives, and childcare needs. Other ANCs found that they lost engagement from members of their community that were less comfortable with technology and missed something from in-person engagement. Both of those experiences are valid. The future likely lies in hybrid meetings, and our committee has provided funding to permit those as well. In the meantime, we believe that ANCs themselves are best situated to understand whether their community is best served through remote, hybrid, or in-person meetings. This legislation, therefore, will continue the authorization for ANCs to meet remotely if they wish, and also tweaks to various elections provisions to ensure an in-person meeting is not required for elections. Finally, the legislation continues existing provisions to ensure that residents incarcerated at the DC jail can elect a commissioner and that their commissioner can participate in their ANC. Since we passed the last version of these bills, however, the Judiciary Committee passed permanent legislation that will either enact or otherwise affect those provisions. That legislation is not yet law, and parts of it are subject to appropriations. This emergency and temporary law incorporates technical changes to match the language of the relevant sections of the upcoming permanent law to avoid unnecessary confusion. I want to thank the Council Budget Office, the Mayor's Office, the CFO's Office, and the Department of Corrections for their partnership in ensuring we could pass this legislation today and that the costs will be absorbed by the agency. Doing so will ensure that our residents at DC Jail can continue to vote and be represented without any gaps while we work on funding permanent legislation. I move the Advisory Neighborhood Commission Pandemic Provisions Extension Emergency Declaration Resolution of 2022.
Thank you, Councilmember White. It's actually the second emergency declaration. We have it before us. Is there discussion? The roll call vote will be on PR 24-1028. Madam Secretary?
Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Silverman,
Yes.
Councilmember Silverman votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White, Councilmember Trayon White, Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Che,
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Member McDuffie votes yes. Chairman Mendelson,
Yes.
Mendelson votes yes. Councilmember Nadeau,
Yes.
Member Nadeau votes yes. Mr. Chairman, there are 11 yeses and 2 absents.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 24-1079. Councilmember White,
So moved, Mr. Chairman.
discussion. Since the declaration was approved unanimously, we'll do a voice vote on this. Votes on Bill 24-1079. All those in favor say aye. Aye.
Aye.
Are there any opposed? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. The next item is foreclosure moratorium and homeowner assistance fund coordination emergency declaration resolution of 2022, PR 24-1029. Councilmember Lewis George.
Yes. Thank you, Chairman. Today I am moving a continuance of the foreclosure protections for homeowners who applied to the DC Homeowner Assistance Fund program before September 30th, the deadline set by the council for phasing out the pandemic-related foreclosure moratorium initially put in place back in 2020. As my colleagues will recall, the federal government promised the district $50 million in homeowner relief to cure housing debts such as mortgage payments, utility bills, and condo fees that were accrued during the pandemic. That money was made available to the district in the spring, and the Department of Housing and Community Development fully opened the DC HAF program in late June. The 2020 foreclosure moratorium remained firmly in place as financial assistance was being stood up and then began to be phased out over the summer, with the expectation that homeowners would need to take action to cure their debts in order to remain eligible for foreclosure protections. More than 1,500 homeowners applied for HAF funding before September 30th, yet most of the applications remain unprocessed. DHCD is working as quickly as they can, but it is a complicated process coordinating with lenders, banks, condo boards, and more. The foreclosure moratorium extension provision and homeowner assistance fund promotion emergency and temporary acts previously passed in June guaranteed protections to all the homeowners who applied for and provided proof of their application to the DC HAF program until, quote, such time as DC HAF payments can be made. With the underlying foreclosure moratorium extension expiring this month, this new round of emergency and temporary measures reaffirms our city's commitment to preventing unnecessary displacement of homeowners who took timely action to cure housing debts. Additionally, this measure requires lenders, banks, condo boards, and others to continue providing notice of the availability of funding from the DC HAF program prior to initiating or continuing any foreclosure actions. The $50 million federal funds has not yet been exhausted, and by continuing to make homeowners aware of the relief program they may benefit from, we can reduce the harms of foreclosure while putting federal funds to good use. I want to thank my colleague, Councilmember Robert White and his team for working with me to ensure this measure better promoted public awareness of DCHAF funding and the very unique opportunity HF provides to us to help us, our city rebound from the pandemic. With that, Chairman, I move the declaration.
Thank you, Councilmember Lewis George. We have the declaration before us. Is there discussion? The vote will be on PR 24-1029. Madam Secretary, would you call the roll?
Councilmember Silverman,
Yes.
Councilmember Silverman votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White,
Yes.
Councilmember Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Che,
Yes.
Councilmember Che votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Lewis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto,
Yes.
Member Pinto votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 24-1080. Councilmember Lewis George.
Yes, Mr. Chairman, I have an amendment to the emergency which would add an applicability date to the bill to ensure there is no gap in coverage of foreclosure protection as the previous temporary comes to its expiration point. I move for the passage of this amendment.
All right, we have the bill before us and we have an amendment. The amendment was circulated by Councilmember Lewis George at something like 10:57 this morning to add the applicability date, as you just said, of November 19th. If there's no objection, the amendment will be accepted. Is there any objection? Hearing no objection, the amendment is accepted. We have the bill as amended. Further discussion?
Mr. Chairman, I just have a question.
Yes.
Maybe you or Councilmember Bonds or Councilmember Lewis George can answer. Before, when we were dealing with the rental assistance program for COVID, we were also at that time having our weekly COVID call meetings so we could ask questions in terms of update. But in reviewing the declaration that Councilmember Lewis George circulated, we have nearly 1,000 applications still remaining pending at this time. I was curious if we have an idea in terms of what DCH or DHCD is doing in terms of trying to clear that backlog. I think when we were trying to get rental assistance out, they assigned more staff and did some other things, and I'm curious if that is happening here.
I do not know. Councilmember Bonds, do you know, or?
It's my understanding that one of the hurdles they're still facing is getting both parties to sign off as much as possible. But of course, if the landlord does not ultimately sign off on it, then the remittance goes directly to the tenant. And so I think they're checking some of the records, some of the information that they had. People are no longer at the address that they were at. So there's a complication of making sure that the records are accurate. That is the understanding that I have.
Councilmember Lewis George?
Yeah, from my understanding, the review process is taking 2 to 3 months on average. And it's the lenders, banks, condo board that are part of the holdups as well. So it's just a lot of moving people and parts.
Got it. Thank you.
Yeah.
Thank you, Mr. Chairman.
Councilmember Henderson?
That was all.
All right, thank
Thank
you.
you.
Anything further on the bill as amended? All right, the vote will be on Bill 24-1080 as amended. Since the declaration was approved unanimously, we can do this by voice vote. All those in favor say aye.
Aye.
Opposed? Madam Secretary, I don't see or hear any no votes. Do you agree?
Agreed, Mr. Chairman.
The bill is approved unanimously. We'll turn to temporary legislation. And generally what we do is I move them all in block. That would be Bill 24-1076, District Government Family Bereavement Leave Second Temporary. Bill 24-1084, CREAC Assistance Fund Temporary. Bill 24-1070, Coronavirus Immunization of School Students Temporary. And to be clear for General Counsel, this will include the amendments that were made to the emergency. Bill 24-1078, the Criminal Justice Involvement Reduction Temporary. Bill 24-1082, Advisory Neighborhood Commission's Pandemic Provisions Extension Second Temporary. Bill 24-1081, the Foreclosure Moratorium and Homeowner Assistance Fund Coordination Temporary. And that also, the temporary will reflect the amendments that were made to the emergency.
Mr. Chairman,
Councilmember Pinto.
can you please move Bill 24-1070 off of the en bloc vote?
Yes,
Thank you.
that means I get to recite it again later. All right, so with that adjustment, and General Counsel, are we clear with regard to including the amendments from the temporaries, excuse me, from the emergency? The one that was removed was the coronavirus one. So the vote will be on items 1, 2, 4, 5, and 6. And I think we'll do this by roll call. That always seems to be the way we go out, is with a roll call. Madam Secretary?
Mr. Chairman, Councilmember Robert White,
Yes.
Member Robert White votes yes. Councilmember Trayon White,
Yes.
Member Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Member Bonds votes yes. Councilmember Che,
Yes.
Member Che votes yes. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Member Henderson votes yes. Councilmember Lewis George,
Yes.
Member Lewis George votes yes. Councilmember McDuffie,
Yes.
Member McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau,
Yes.
Member Nadeau votes yes. Councilmember Pinto,
Yes.
Member Pinto votes yes. Councilmember Silverman,
Yes.
Member Silverman votes yes. Mr. Chairman, there are 12 yeses and 1 absent.
The 5 temporaries are approved unanimously. I'll move the temporary for Bill 24-1070, the Coronavirus Immunization of School Students Temporary Amendment Act, including the amendments that were made to the emergency. Madam Secretary, would you call the roll?
Councilmember Trayon White,
Yes.
Councilmember Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Member Bonds votes yes. Councilmember Che,
Present.
Councilmember Che will be recorded as present. Councilmember Gray is absent. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Member McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Pinto,
No.
Councilmember Pinto votes no. Councilmember Silverman,
Yes.
Councilmember Silverman votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 10 yeses, 1 no, 1 present, and 1 absent.
The bill is approved first reading. That's going to conclude the business for this legislative meeting. We have a committee of the whole meeting on November 15th, and there will be an additional legislative meeting at that time. Following that, there will be a regular legislative meeting on December 6th. The time is 4:40 in the afternoon, and this meeting is